Judiciary Committee will come to order. Today we will hear from 5 nominees. Judge Gustavo Gelpi, nominated to the First Circuit. Judge Angel Kelly, nominated to the District of Massachusetts. Christine O'Hearn, nominated to the District of New Jersey. Helene Greenfield, nominated to lead the Justice Department's Office of Legislative Affairs, or OLA. And Christopher Schrader, nominated to lead the Justice Department's Office of Legal Counsel, or OLC. I'll introduce 2 of the nominees, and we'll hear from a number of our colleagues today to introduce the remaining 3. Before I make my introductions, I'd like to extend a note of thanks to Chair Durbin for the opportunity to preside at this hearing. The committee does enormously important work, and these nomination hearings are no exception. So thank you, Chair Durbin. Turning now to the introductions. First, I have the privilege of introducing Judge Gustavo Gelpi, who has been nominated to the First Circuit Court of Appeals. Judge Gelpi currently serves as a United States District Court Judge for the District of Puerto Rico, a position he's held since the Senate unanimously confirmed him to that role in 2006. In his time on the bench, which included 5 years as a federal magistrate judge before his appointment to the district court, Judge Gelpi has presided over some 3,400 cases, including 62 jury trials. He's written more than 880 opinions on a range of legal and constitutional issues, from Social Security benefits to the Federal Tort Claims Act to the First Amendment. Judge Gelpi came to the district court with a unique and varied perspective, having served as both a federal public defender and with the Puerto Rico Department of Justice, where he handled criminal matters on behalf of the Attorney General of Puerto Rico. And he'll bring that same perspective, along with 2 decades of judicial experience, to the First Circuit. It's no surprise, then, that the American Bar Association unanimously rated Judge Gelpi well qualified. I'd also note that when confirmed, Judge Gelpi will be just the 2nd judge from Puerto Rico to ever sit on the First Circuit, and likewise, the 2nd judge of Hispanic origin to serve on that same court. Congratulations to you and your family, Judge Gelpi, and we look forward to hearing from you in just a few minutes. It's also my privilege to introduce Christopher Schrader, nominated to lead the Office of Legal Counsel. Mr. Schrader currently serves as a Deputy Assistant Attorney General at OLC, and in many respects, his nomination to head this office is something of a homecoming. His first stint in that office was in 1993, when he served as a counselor to the Assistant Attorney General. Mr. Schrader is also well known to this committee. He served as a Special Nominations Counsel and Chief Counsel to the Senate Judiciary Committee when now President Biden was the committee chairman. And during the Obama administration, he served for 3 years as the Assistant Attorney General in charge of the Office of Legal Policy. In addition to his government service, Mr. Schrader spent more than 40 years in legal academia as a professor of law and public policy at Duke University School of Law, where he taught classes on environmental law, constitutional law, administrative law, property, civil procedure, and fittingly, Congress and the legislative process. Congratulations to you and your family as well, Mr. Schrader, for your nomination, and we look forward to hearing from you on the 2nd panel. Is Chair Durbin with us? Before I turn to Ranking Member Grassley for his opening remarks, I'd like to recognize Chair Durbin to make brief opening comments.
Senator Ossoff, thank you very much for chairing this hearing. As I mentioned to several, I have to testify in the House this morning, and I won't be able to stay, but you're in good hands, I say to all the nominees. Senator Ossoff is one of our most recent additions and an invaluable member of the committee. As he mentioned, we have 5 outstanding nominees before us. Senator Ossoff has already introduced 2, Judge Gelpi and Christopher Schrader. The committee will also hear from Judge Angel Kelly, nominated to the District of Massachusetts, and Christine O'Hearn to the District of New Jersey. I'd like to say a word, and I'm sure there will be much more said by Senator Leahy, appropriately, about the final nominee, Helene Greenfield, nominated to the Justice Department's Office of Legislative Affairs. I know that both Senator Leahy and Senator Hirono will make formal introductions, but I want to add a word. In a very real sense, Ms. Greenfield has been the mainstay of this committee's work. From her time as Chief Nominations Counsel to Senator Leahy, to her work as Chief Counsel to Senator Hirono, Ms. Greenfield has been a widely respected staff member, a wonderful colleague, and a mentor to so many people. She has now been given what some might consider a tough assignment, responding to the request from this committee. We know, though, that she's up to it and that she will serve the Justice Department in the way she served this committee, with professionalism, integrity, and dedication. Thank you to all the nominees, and with that, I turn it back to Senator Ossoff.
Thank you, Mr. Chairman. Now I'd like to turn to Ranking Member Grassley for any opening statement he wishes to make.
I congratulate all the nominees, and I'm going to take my time not so much to talk about the nominees as a couple other issues that's related to the judiciary. Last week, the Supreme Court threw out the latest Obamacare suit. Justice Barrett joined Justice Breyer's opinion doing so. Now, I'm old enough to remember when my Democrat friends insisted that the main reason we were confirming Justice Barrett to the Supreme Court was so that that new justice could dismantle Obamacare in that very case. And of course, that turned out to be nonsense, and it was a nonsense at the time it was stated. But my colleagues still boycotted the markup and left in their place pictures of children who would supposedly lose their health care if Justice Barrett was confirmed. It was fear-mongering, and of course, we know now they ought to be convinced that it was false. Have any Democrats apologized to Justice Barrett for questioning her integrity? Of course not. In fact, one Democrat went so far as to say that maybe the attacks on her character bullied her into voting the right way. It's sad that Democrats see judges as mere politicians, beholden to special interests and vulnerable to personal attacks. But it's also refreshing to see independent judges like Amy Barrett and Brett Kavanaugh do the right thing under the law. I also want to talk a little bit about judicial philosophy. My Republican colleagues and I have asked Biden nominees many questions about judicial philosophy. Some of those may be asked of our nominees today. We don't often get an answer, hardly ever. In fact, they seem to be allergic to the very idea of judicial philosophy. They won't agree to being originalists or textualists. They won't oppose the living Constitution. Now, that's fair enough. They're Democrats. But they won't embrace that living constitutional philosophy either. It seems they just don't want to talk about philosophy at all. To me, this means one of two things. It could mean that they're interpretive liberals and they don't want to admit it. Namely, they believe in the liberal method of interpreting the Constitution like Justice Brennan or an interpretive statute like Judge Posner. But don't feel comfortable defending those views in public. Or more troubling, it could mean that they're being honest and they don't have any interpretive method at all. And it really is just politics all the way down. I've started to ask nominees about whether law is just politics. How do they view law generally? How does the law relate to politics? Where does morality fit in? Where does the law get its power? They aren't any more forthcoming on jurisprudent questions than they are in interpretation questions. Now, our colleague Senator Kennedy has observed, surely they've thought about this, meaning what I just spoke about. They've thought about. And he observes that all of these nominees are very smart people, and they are smart people. I have no doubt that President Biden and demand justice expect them to have thoughts about these issues. So what's the point in hiding your judicial philosophy? And they are hiding. Chairman Durbin recently quoted a Trump nominee saying he or she didn't like labels, to argue that nominees over the last 4 years didn't answer questions about judicial philosophy either. And of course, that's just not correct. It's true some Trump nominees didn't embrace the originalist label, but not all Trump nominees were originalists. The fact is that the Trump nominees didn't run from their beliefs. Neil Gorsuch said, quote, "I'm happy to be called an originalist." Amy Barrett agreed, quote, "I'm an originalist." I count at least a dozen Trump circuit and district nominees who either identified as originalists or said that they subscribe to originalist or textualist methods when asked. Maybe that's why so many Democrats voted against them. Maybe Democrats today figure a diverse group of criminal defense judges will reach policy outcomes that they like, and that's good enough for them. But it's not good enough for me, or I suspect the American people. It shouldn't be good enough for any senator who views the role of a judge as someone who will impartially follow the law and not just be a partisan in robes. So we're going to keep asking about judicial philosophy to see if Biden nominees can defend their views of the judiciary and the rule of law. We'll see if any of our friends on the other side join us in that effort. As to today's nominees, we surely won't get this kind of equivocation from Judge Gelpi. A replacement for the phenomenal Judge Raul Arias, whose nomination was unfortunately withdrawn by Biden. Judge Gelpi has a long history as a judge in Puerto Rico, where he has also opined at great length on multiple languages on his constitutional views. He even wrote a book about constitutional history. I look forward to discussing those views with him. Judge Kelly and O'Hare have interesting records that I'll want to talk about. Mr. Schroeder and Ms. Greenfeld are old hands at their respective positions, and I can only hope that they will give them the expertise and knowledge they need to assist me in my oversight requests at the Justice Department, which, by the way, for all members of this committee, I still haven't got my documents from Garland that we wrote about 6 or 8 weeks ago. Thank you all.
Thank you, Ranking Member Grassley. We'll now hear from several colleagues who are joining this morning to introduce nominees, beginning with Senator Leahy, who will introduce his former aide, Helene Greenfeld.
Thank you, Mr. Chairman, and I apologize. I'm going to have to be brief because I'm going to the memorial service for a dear friend and former colleague, Senator John Warner. But it is great pleasure to introduce Helene Greenfeld this morning. She's dedicated her career to public service. And I take special pride, though, in noting that Helene Greenfeld's first job on Capitol Hill was as my counsel on this committee. And I knew how well she'd do. She graduated at the top of her law school class at Georgetown Law, also my alma mater, and continued on doing amazing things. And she was an instrumental player in the confirmation of the late Justice Ruth Bader Ginsburg. And it's no exaggeration that her tireless work to get Justice Ginsburg confirmed changed the world. She joined my Judiciary Committee team as I took over as chairman for the first time in 2001. She was my senior nominations counsel. I was a brand new committee chairman. I had a lot to learn, and she was by my side throughout those years. And now, in thinking of what the ranking member just said about should we look at people as individuals, she guided me through 2 Supreme Court nominations. One of those was the nomination of Chief Justice Roberts. Now, I know a number of Democrats opposed Chief Justice Roberts. I'm proud to say I crossed party lines, and I supported Chief Justice Roberts' confirmation because our Supreme Court, the crown jewel of our independent judiciary, is so much more important than partisanship. But it is her wise counsel that helped me on every one of these and helping us get a number of lifetime judgeships through. And I think I can say I have voted for probably more Republican nominees as judges than virtually any Republican member of this committee when we speak about partisanship. But she helped me get through judges, no matter what their political background were, if they're the most qualified. I also know what a great sense of humor she has. I can remember walking down the halls and hearing this roars of laughter coming from her office as she was briefing the staff and getting things ready. So I look forward to supporting her throughout this. I would ask my full statement be placed in the record, but I can tell you we could not have a better person. Thank you.
Thank you, Senator Leahy. Please give our respects to Senator Warner's family. And now Senator Hirono will join in introducing Ms. Greenfeld.
Thank you, Mr. Chairman. If you listed the ideal qualifications, skills, and experience for someone nominated to serve as Assistant Attorney General for Legislative Affairs, you'd be hard-pressed to find someone with more suitable experience for the job than Helene Greenfeld. Over the 2 years Ms. Greenfeld served as my chief counsel, I came to depend on her expertise, professionalism, and strategic advice. I also benefited regularly from her years of experience serving in the Department of Justice and on the Hill. It is precisely this combination of skill and experience that makes Ms. Greenfeld well-suited to this role and why I enthusiastically endorse her nomination. Over the years, members of the committee on both sides of the aisle have expressed frustration with DOJ's lack of responsiveness to congressional oversight and requests for technical assistance and other information. I have shared this frustration at times myself. Having worked in both the executive and legislative branches of government, Ms. Greenfeld understands and respects Congress's responsibility to conduct oversight. She also understands that timely information from DOJ is an essential tool for Congress to legislate effectively. As a member of OLA leadership since the beginning of the Biden administration, Ms. Greenfeld is already setting a positive tone in the relationship between Congress and DOJ. I saw this firsthand earlier this year when DOJ provided timely and important technical assistance on the COVID-19 Hate Crimes Act. Working on a bipartisan basis, we were able to incorporate elements of DOJ's guidance into the bill, which passed the Senate almost unanimously and which President Biden ultimately signed into law. I understand that other members of Congress have enjoyed similar productive dialogue with OLA, and I'm sure Ms. Greenfeld will speak more about this subject during this hearing. On a personal note, I can vouch for Ms. Greenfeld's professionalism and character, and yes, her sense of humor, and I know how much her family's experience as Jewish refugees fleeing the Holocaust drove her to a life of public service. I know she will excel in the role to which she was appointed and offer a strong endorsement for her confirmation. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Now Senator Warren will introduce Judge Angel Kelly.
Thank you, Senator Ossoff and Ranking Member Grassley. Today I have the privilege of introducing Massachusetts Superior Court Judge Angel Kelly, who has been nominated to serve as a judge on the Federal District Court of Massachusetts. Judge Kelly's 28-year legal career has provided her excellent preparation for joining the federal bench in Massachusetts. Judge Kelly has served as a judge in the Commonwealth since 2009 as an associate justice on both the State District Court and Superior Court in Brockton. She also served as a regional administrative judge from 2017 to 2020. Judge Kelly's legal career has also consistently centered on public interest. She began her career working as a staff attorney in the Juvenile Rights Division at the Legal Aid Society in New York, where she served as a law guardian in child protective matters, representing abused and neglected children. She also worked as a public defender in juvenile delinquency cases. Her public service career continued in the law department of the Port Authority of New York and New Jersey, and later as an assistant U.S. attorney in Boston for 2 years. Judge Kelly also taught at the Legal Aid Bureau at the Harvard Law School, where she supervised students in probate and family court and taught courses in family law and litigation skills. Judge Kelly is supremely qualified to serve on the Federal District Court in Massachusetts. In addition to her professional commitment to public service, Judge Kelly has made it a personal mission to bring about change through her role on the bench, both in her courtroom and in the courtrooms of her colleagues. For years, Judge Kelly has led efforts to encourage our state courts to reflect on and publicly acknowledge the injustices that Black Americans have long faced in this country. Those efforts have included community listening sessions and educational events on race, including a conversation on, quote, confronting racism in the courts for Massachusetts judges. In 2019, Judge Kelly single-handedly organized a judicial educational program to travel to Montgomery, Alabama, to visit the Equal Justice Initiative's Legacy Museum. Judges and their families traveled to Montgomery to meet with members of the Alabama judiciary, to tour the Legacy Museum and National Memorial for Peace and Justice, to visit the Rosa Parks Museum, and to reflect as a group on the role of the judiciary in our country and the implications of judicial decisions on the broader society. I could go on and on about her personal and professional qualifications for the bench. Judge Kelly has demonstrated a deep commitment to advancing equal justice under law, and she has gone out of her way to educate her colleagues on how they can bring about a more equitable legal system. I have no doubt that she will continue this work on the Federal District Court in Massachusetts. I want to say a welcome to Judge Kelly and congratulations on your nomination. And also welcome my colleague and partner, Senator Markey.
Thank you, Senator Warren, and Senator Markey, you're recognized to join in the introduction of Judge Kelly.
Thank you, Mr. Chairman, very much. And I'm just going to add on to what Senator Warren just presented to the committee, which is that it is a pleasure for us to be able to recommend for confirmation Judge Angel Kelly to serve as a judge on the United States District Court for the District of Massachusetts. In a legal career that has already spanned almost 30 years, Judge Kelly has excelled in everything she has done, and she has done a lot. She has been a trial attorney, a legal instructor, a state court judge in our home state of Massachusetts. She has devoted her entire professional career to public interest and public service work. She began her practice of law representing children in delinquency and protective care cases in New York. She went on to serve as a senior trial attorney and assistant chief for litigation in the fast-paced and demanding Port Authority of New York and New Jersey. She served as an assistant United States attorney. If you Google the words public service, Judge Kelly's picture pops up. It's been her life. She has taught litigation skills to students at Harvard University Law School and supervised them representing indigent clients appearing in probate and family court. And as a judge sitting in Massachusetts District and Superior Courts, she has presided over several hundred jury trials that have gone to verdict or judgment. Judge Kelly has throughout her career demonstrated one thing above all else, and that is an abiding commitment to our nation's promise of equal justice under law. She has been a leader in the Massachusetts judiciary on fulfilling this promise, especially to litigants of color. And she has been a friend and mentor to many members of the legal community and their affinity groups, with her nomination receiving strong support from the Massachusetts Black Lawyers Association, the Massachusetts Hispanic Lawyers Association, and the Asian American Lawyers Association of Massachusetts, among others. At a time when our federal bench needs both diversity in experience and background more than ever, Judge Kelly meets the moment with a set of experiences that are unfortunately too rare for federal judges. It is my sincere hope to see more nominees like Judge Kelly in the near future as we help reshape America's judiciary to better suit the people that it serves. In light of Judge Kelly's qualifications, expertise, and service, I respectfully ask that you send her nomination to the full Senate for confirmation, and I hope that the Senate will quickly confirm her to fill the long vacant seat on the Massachusetts Federal Court. Thank you, Mr. Chairman.
Thank you, Senator Markey, and Senator Menendez is now recognized to introduce Christine O'Hearn.
Well, thank you, Mr. Chairman, distinguished ranking member, members of the committee.
Before I do that, I want to take a moment as the highest-ranking Latino in the United States Congress to first acknowledge a historic nominee to the United States Court of Appeals for the First Circuit, Judge Gustavo Gelpi. Judge Gelpi will be the only second judge of Hispanic origin and the second judge from Puerto Rico ever to sit on the First Circuit. He is deeply respected among his colleagues in the judiciary and a beloved member of the Puerto Rican legal community. As Governor Pierluisi, who is here with him, the governor of Puerto Rico, can tell you, there is very little unanimity on many issues in Puerto Rico. There is unanimity on the incredible judge that Judge Gelpi is. I believe he will make an outstanding contribution to the First Circuit. It's also my great privilege to join with my distinguished colleague of this committee, Senator Booker, to introduce our exceptional nominee to the U.S. District Court for the District of New Jersey, Ms. Christine O'Hearn. She's born and raised in New Jersey. She is an expert in labor and employment law, highly regarded among her colleagues for her sharp intellect. Ms. O'Hearn was twice named one of the top 40 attorneys under 40. I forgot what that was like, but top 40 attorneys under 40 in New Jersey, and was featured in New Jersey's law journals Women and Minorities in the Profession. Ms. O'Hearn is currently a partner of Brown and Connery in Westmount, New Jersey, where she practices labor, employment, and complex civil litigation. In 2020, Ms. O'Hearn was appointed to the U.S. Magistrate Judge Selection Committee, which in essence works to select all of the magistrates of the federal district, and has served on various distinguished boards, including the New Jersey State Committee of the American College of Trial Lawyers and the New Jersey Court District 4 Ethics Committee. She also previously served as an adjunct professor at Rutgers University School of Law in Camden, preparing the next generation of lawyers. It's clear to me that Ms. O'Hearn has the astute judgment, even temperament, deference to precedents necessary to excel as a federal judge. I am confident she will serve the people of New Jersey well through her administration of fair and impartial justice. I'm very proud to have recommended her for appointment to the U.S. District of New Jersey. And I would just close, Mr. Chairman, by saying I think the committee knows, and I appreciate that the chairman has been working to move some of these nominees. New Jersey has a series of multiple vacancies which have been declared judicial emergencies by the Judicial Conference of the United States. Therefore, I ask your unanimous support and quick expedition of reporting out Ms. O'Hearn to the full Senate. Thank you very much.
Thank you, Senator Menendez. I'd like to join you as well in welcoming and acknowledging the presence of Governor Pierluisi. And now I'd like to recognize Senator Booker, who will join in the introduction of Ms. O'Hearn.
Mr. Chairman, I'm grateful to have this opportunity to follow the senior senator of New Jersey in heralding the qualifications of Christine O'Hearn, who I am excited that the President Biden has nominated to be a U.S. District Judge for the District of New Jersey. My senior senator, Menendez, has already spoken to her qualifications. I will add that Ms. O'Hearn is truly Jersey through and through. She is the best of our state, and I have heard rumors that both Bruce and Bon Jovi are jealous of her Jerseyness. She was born in Camden, New Jersey. She went to the University of Delaware, who anybody that knows University of Delaware, it is a very Jersey school. She taught at Rutgers University Law School in Camden, and she has practiced her career in Westmont, New Jersey since 1993. She has decades now, 28 years as a career litigator. She has demonstrated herself to her peers and members of the Judiciary New Jersey as an extraordinarily exceptional litigator. She's represented both defendants and plaintiffs in a variety of issue areas that will be very indicative of her qualifications to be a judge, to be fair, balanced, even-handed, judicious, and compassionate. What is really striking to me is her commitment to serving others. She has logged many, many hours of pro bono work serving on New Jersey Supreme Court District 4 Ethics Committee, helping to provide oversight and integrity to her peers in the New Jersey legal community. And she has been recognized by New Jersey lawyers for those qualifications, and as Senator Menendez mentioned, distinguished herself early in her career. She has demonstrated a deep commitment to the values that we hold most sacred in our nation. She understands that her role is to uphold public faith in the law and to make sure that no matter who comes before the bench, that they are treated with justice and equanimity. Christine O'Hearn's commitment to the law and her breadth of experience will make her a truly capable jurist. And as Senator Menendez said, there is an urgency in New Jersey, not just to fill judicial vacancies, but to fill them with people of honor and integrity and qualifications. Ms. O'Hearn meets that measure and will make our state even more proud to have her. I hope that we will move her through this committee quickly and get her to the floor for a vote. And as a Jersey boy myself, it will be one of the prouder votes that I take on the floor to vote for her confirmation.
Thank you, Senator Booker. Now just ask for everyone's patience for a moment as we finalize the setup for our first panel. Judge Gelpi, would you please stand to be sworn? Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Judge. Please proceed with your opening remarks.
Good morning, Senator Ossoff, and it's a privilege to appear before you. This is the first hearing you're chairing in this committee. I also want to thank Senator Menendez, as well as you, for making some introductory remarks, so I appreciate that. I also want to thank the President of the United States, President Biden, for this nomination, and the chair of the committee, Senator Durbin, as well as the ranking member, Senator Grassley, for making this hearing possible. And I want to thank all the members of the committee who are also here today. It is an honor to be here. I was before this committee 15 years ago for my district judge nomination. Many of the senators are still here. That was, at the time, the greatest honor of my professional life. If confirmed for this position, this would be an honor above that honor. I have been a public servant for almost 30 years, and I have been a judge now for 20 years. I was a magistrate judge for 5 years, and I've been a district judge now for 15 years. And if confirmed, I will continue to apply the rule of law and our Constitution and laws to the cases that come before me with the same passion and commitment as I've always had. Present with me today are family members, my father, who looks like me, Maria, law school colleagues and childhood friends. I thank you also for introducing Governor Pierluisi, who's here, and I appreciate his being here. Not here with me today is my mother, who's in Puerto Rico, as well as my children, Diego and Maria, but they're here in spirit. Also, not present with us today, but present in spirit are my 3 grandparents who were integral part of my upbringing. My 2 maternal grandparents. My father was a disabled World War II veteran. His wife was a naturalized U.S. citizen. And on my dad's side, my grandmother worked for the U.S. Navy as a civilian for 43 years. That's a record, a personal family record I hope to break someday. And I also want to thank all my friends in Puerto Rico and across the nation who have supported me, as well as other individuals who have supported me all the way through these proceedings. I welcome your questions, and thank you, Senator.
Thank you, Judge Gelpi. We will now turn to questions. Senators will have 5 minutes to question the nominees in this first panel. And I'll begin, Judge Gelpi. Thank you again for joining us today. Congratulations again on your nomination and your years of distinguished service. You bring a unique background to the bench, having worked in the Federal Public Defender's Office in Puerto Rico, where you represented defendants who lacked the resources to retain their own counsel. You served on the U.S. Sentencing Commission, where you worked to revise guidelines, and you've also served as a prosecutor. And of course, you have extensive experience on the bench for the past 2 decades, first as a magistrate and now as a federal district court judge. Judge Gelpi, can you address how this broad view and broad experience at multiple levels and in multiple roles in our justice system informs your understanding of justice and the rule of law in the United States today and will guide your approach to judicial decision-making should you be confirmed to this judgeship?
Senator, as an attorney during the first third of my professional career, I appeared before the trial courts, federal courts, and also courts of appeal representing clients, both on the criminal side and then representing the government on the government side. I think that experience as an attorney was important for me as a judge to see the challenges that attorneys have. On the criminal side, it's important to recognize that attorneys have a constitutional right to represent their clients. And also on the civil rights, attorneys have ethical considerations and they need to hold their representation to the higher standards. That is very important because I have been there, as I said, at the trial and appellate levels. As a magistrate judge, it was a very unique, important experience also because the magistrate judges are usually the first face of the federal court any person who's arrested sees. Magistrate judges also work carefully in settling cases, in the discovery phase of cases. And as a district judge for the last 15 years, I've had tried numerous criminal, civil cases of all sorts, ranging from drugs to illegal firearms. On the civil side, I've had antitrust cases, I've had maritime cases, I've had civil rights cases. And that gives me a unique experience. And I've also had the opportunity as a district judge to sit by designation on 4 occasions on the Court of Appeals. So I've been able to see the dynamics of sitting on a panel and resolving cases before me with 2 other judges, which is different from being the sole decision maker. I also, being a judge for these years and presiding over so many cases, I have also cherished the role the jury plays in our justice system, and that is a very unique experience. I've seen the jury from an attorney's perspective, also from a judge's perspective.
Thank you, Judge Gelpi. And in addition to Governor Pierluisi, I want to acknowledge that Representative Gonzalez Colon, delegate from Puerto Rico, has joined us. Thank you, Representative. And at this time, would recognize Ranking Member Grassley for 5 minutes.
Yeah. Judge Gelpi, you've been an outspoken person in your opposition to the so-called insular cases because of their effects on Puerto Rico. But for almost a decade, the government of America Samoa has invoked the insular cases in court to protect what they call the Samoan way of life. Just last week, Judge Carlos Lucero of the 10th Circuit agreed with the America Samoa, saying, quote, "The flexibility of the insular cases framework gives federal courts significant latitude to preserve traditional cultural practices that might otherwise run afoul of individual rights enshrined in the Constitution," end of quote. What effect would your constitutional position have on an unincorporated territory like America's Samoa that has relied on those cases for almost a century to preserve both its unique culture and its American sovereignty?
Senator, the insular cases that were decided in the early part of the 20th century were based on racist underpinnings, and the Supreme Court that decided those cases was basically the same Supreme Court that decided Plessy versus Ferguson. So my criticism of those cases is in the historical aspect. Now, as a sitting judge, and if confirmed to the Court of Appeals, I will continue to be a sitting judge The question you have posed is a question that is currently before the 10th Circuit. It was, as you correctly stated, it was decided last week. It may be an en banc sitting that may be asked by the parties or may go to the Supreme Court. So as a sitting judge, I do not think it's proper for me to answer that question. But I hope my earlier answer has at least added something to my response.
You have written and spoken extensively on Puerto Rico's territorial status under the Constitution, denouncing it as colonialism. You even wrote a book about it. Will you commit to recuse on any future cases involving Puerto Rico's territorial status, given your extensive commentary on the issue? And let me continue to ask another question along that line. Could you point me to any territorial status cases where you have held the law compels an outcome different from those you have advocated for in your writing?
Senator, I have had over my 15 years experience as a district judge several cases involving the constitutional relationship between Puerto Rico and the United States. That is a very small fraction of my overall docket. I have always upheld the Constitution and laws of the United States when resolving the issues pertaining to Puerto Rico's status, even though those issues may be adverse. And in most occasions, my rulings have been adverse to Puerto Rico's citizens or status, but I apply the law to the facts of each case. If the issue of recusal were to come before me, it's an issue I have to decide on a case-by-case basis. I have made expressions regarding the territories as part of my opinions, but it's been these expressions have been made based on matters that have been raised by the parties in the proceedings before me. Like any other case, I will look at the Code of Judicial Conduct and determine on a case-by-case basis whether recusal is warranted or not.
My last question for you. You had a case regarding disability payments in Puerto Rico where you ignored a 1980 Supreme Court judgment that Congress should prevent prevent such payments by saying your court cannot simply bind itself to the legal status quo of 1980 and ignore important subsequent developments in the constitutional landscape, end of quote. One such subsequent development you identified was the gay marriage case of Windsor. This is in stark contrast to what your mentor, Judge Jimenez, said in Puerto Rico gay marriage case. He addressed Windsor saying that he, quote, cannot see how any doctrinal developments at the Supreme Court changes the outcome of prior Supreme Court precedent or permit a lower court to ignore it, end of quote. He waited for the Supreme Court to overturn its precedent. He didn't do it at a trial court. Was Judge Perez wrong?
Senator, the case you're referring to is now before the U.S. Supreme Court. That's United States versus Baello Madero. And I have to note that there are very similar challenges presently before me and other federal judges. So in that respect, I should not give an opinion about the case. I do want to note that when I decided Baello Madero, which has been confirmed by the First Circuit, is now before the Supreme Court, the arguments that were raised before me were arguments that had not been made in the 1980 cases. So I resolved those arguments that had not been raised before, and those are the arguments that will, I assume, be before the United States Supreme Court.
I thank you very much. And
Thank you, Senator.
Congratulate you on your nomination.
Thank you, Senator Grassley. Senator Hirono is recognized for 5 minutes.
Thank you, Mr. Chairman. Governor Pierluisi, it's good to see you. Welcome to this proceeding. I asked the following two questions of all nominees before any of the committees on which I sit, so I will ask you, Mr. Gelpi, these questions. First of all, since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
Senator, the answer is absolutely no.
Have you ever faced discipline or entered into a settlement refer to this kind of conduct?
Senator, same answer, absolutely no.
So Senator Menendez, while he was here, noted that you would be only the second Hispanic on the First Circuit Court. Is diversity on our federal courts important?
Senator Hirono, diversity is important in all courts. And diversity comes from my own DNA or the DNA of any judge, but also comes from my professional experience. If I were to be confirmed to the Court of Appeals for the First Circuit, I would bring my diverse experience. And panels in any appellate court are composed of 3 judges. And the judges are all diverse. I sat on the Court of Appeals. For the First Circuit, it's a very small court, 6 judges, 2 senior judges. So you get to sit in that court with different judges every time. So there is diversity every time you sit on a panel. Again, as I said, DNA diversity and also experience brings diversity.
Thank you. Between your time as a magistrate judge and as a district court judge, you have been on the federal bench for 20 years. What have you learned during that time that you will take with you if you are confirmed to the First Circuit?
Senator, if I'm confirmed to the First Circuit, I've learned as a magistrate judge and then a district judge, it is very important to listen to the parties carefully, hear the arguments, respect the lawyers, respect the parties. Everybody must be treated equally. It is very important to always give every case the same type of hard work. There may be huge cases, small cases, but for every case, for every party, that is their case. So everybody needs to have that same attention. And that is something I would definitely, based on my experience, I would continue doing at the Court of Appeals level.
You've also sat by designation on the First Circuit Court a number of times. What are some of the key differences you see between the role of a district court judge in comparison to a judge on the circuit court?
Well, as a district court judge, I presided over cases acting in my own capacity. I'm there by myself. And if these cases reach trial, I have to preside over, usually it's going to be, most of the time, it's going to be a jury trial. So I have to preside over that event and make sure that the jury is instructed and that certain rules of trial are held. At the appellate level, it is different because I would be working with 2 other colleagues, or if the case is heard en banc with 6 other colleagues, or 5 other colleagues, I mean. And you have to decide decisions on a consensus basis. So it is also different in that respect. And also, at the appellate level, I would be reviewing trial records from cases that are decided at the district level. So it is, appellate review is different in that respect from presiding over cases.
Well, you are obviously well-suited in either position, I'd say. You've spoken on the importance of your role in overseeing a consent decree between the U.S. Department of Justice and the Commonwealth of Puerto Rico's Police Department, calling it, and quoting you, one of the most satisfying and rewarding functions in which a federal judge can engage in, end quote. What did you find so rewarding about this experience?
Senator, the consent decree that I preside was a consent decree filed by United States Department of Justice against the Commonwealth of Puerto Rico, and it was the result of an investigation by the Department of Justice that demonstrated that in Puerto Rico there was a pattern and practice of unconstitutional policing, profiling, discrimination based on sex, promotions, there are no policies. And the idea of the consent decree is we had a 4-year capacity building period, which I oversaw, where the case is now in its monitoring stage. But it is very important to see, and it's very rewarding that, for example, there is a police academy now that has a curriculum, and the police officers are trained. They get trained on use of force. There are policies. In the past, for example, no woman was a high-ranking colonel. At some point, women would get stuck in the system. Now, it's based on merit. There are women who are commanders. They're colonels. So in that sense, it's very rewarding. And I have gone to police academy graduations. You see the pride these officers take. There is continuing police education similar to continuing legal education, which attorneys and judges take. And it's a matter of ensuring that police will constitutionally protect the public, and at the same time, the police officers are trained to be the best police officers they can.
There are a number of us on this committee who recognize the important role that consent decrees have in just and fair policing. Thank you very much, Mr. Chairman.
Thank you, Senator Hirono. Senator Tillis is recognized for 5 minutes.
Thank you, Mr. Chairman. Judge,
Good morning.
welcome, and congratulations to you and your family for the honor of your nomination. I have a quick question on United States versus Mercado Perez. Are you familiar with that case?
Yes, sir.
The grand jury returned a one-count indictment charging the defendant with transporting a 14-year-old female minor within the Commonwealth of Puerto Rico with the intent to engage in criminal sexual activity. And I believe the defendant pleaded guilty, but you ruled that Section 2421 of Title 18 of the United States Code does not apply to a wholly intra-Commonwealth transportation of an individual with the intent to engage in criminal sexual activity. The First Circuit later vacated your opinion, but can you give me some sense of the reasoning behind your ruling?
Yes, Senator. Let me say that in Puerto Rico, we do have, unfortunately, a large number of these cases involving sexual abuse or sexual acts against minors. I have always taken these cases extremely seriously and have applied the law, applied the sentencing guidelines, and applied the law as required. This particular case, the defendant, I sentenced him pursuant to the plea agreement. I believe it was 57 months. And then after the sentence, I determined that there was a jurisdictional issue. So the sentence was vacated on the jurisdictional ground. That is the matter that went to the Court of Appeals. The Court of Appeals understood that I had no jurisdiction to discuss the jurisdictional issue, so it got remanded, and I resentenced the defendant to the sentence that I originally imposed. But it was a procedural jurisdictional issue.
Okay, thank you. Have you ever heard a case on qualified immunity for a law enforcement officer?
Senator, yes. In Puerto Rico, we have a large portion of our civil rights cases involve police misconduct, and the doctrine has been raised on numerous cases.
And going through those cases, do you believe that the current jurisprudence provides sufficient protection for law enforcement officers, current settled law?
Senator, as a sitting judge for 20 years, I have applied the doctrine of qualified immunity when the facts and the law are appropriate. Other cases, I have found there's no qualified immunity, but it's a doctrine that was created by the Supreme Court several decades ago, and I have to apply it. There's also First Circuit jurisprudence. If as long as that is the law and the law doesn't change, that is what I have to apply.
Okay, thank you. Congratulations again.
Thank you,
Mr.
Senator.
Chair.
Thank you, Senator Tillis. Senator Blumenthal is recognized for 5 minutes.
Thanks, Mr. Chairman. Thank you for your service, and you are extraordinarily well qualified as a public defender, as an assistant attorney general in an office that I know well and respect from my own days as attorney general and now as a judge for some 20 years. And I agree with you totally on the need for diversity and really welcome your nomination. Congratulations to you. I would like to ask you whether you feel that we need more judges. Obviously, you can't speak to the appellate court level, but at the district court level, based on your experience in the District of Puerto Rico and your conversations with your colleagues around the country, do you feel that we need to expand the number of federal trial court judges, district court judges, to meet the backlog that has accumulated and the increasing workload that they face?
Senator, that is a matter which the Judicial Conference of the United States every 2 years makes reports to the Congress of the United States. And in fact, there are, depending on the district, there are certainly districts that require, based on that data, would require, based on the workload, additional judges. For example, the District of Puerto Rico, in my experience, it's 7 judges. And that was that hasn't changed since 1979, the number of judges. At certain points, the Judicial Conference has recommended an 8th position. I have also seen that there are districts that the opposite has been recommended, that if there's a future vacancy, to eliminate that position. And that's something the Judicial Conference and the Congress work together for district judgeships. But I can say for sure in Puerto Rico, there have been requests for an 8th judgeship at particular points in time.
How do you feel about the representation that Puerto Rico lacks right now? How do you feel that that may have affected the resources available to the judicial district in Puerto Rico? Would you expect that more would be allocated if Puerto Rico had representation in the Congress?
Well, Senator, your question, in a sense, is a political question, which poses whether Puerto Rico will become a state or not. So, as a judge, I cannot answer that from that perspective. But I do want to say that the Judicial Conference of the United States has always treated Puerto Rico as an Article 3 district court. It's a constitutional court. Judges are appointed for life. And from my perspective, within the judicial branch, Puerto Rico is treated equally, just like any other district in the nation. So when the Judicial Conference makes a request to the Congress, it takes Puerto Rico into account, just like it takes into account any other district.
Do you think that the First Circuit is the right place for Puerto Rico, or should it be possibly the Second Circuit?
Senator, historically, the First Circuit, Puerto Rico has been part of the First Circuit since 1915, so it's been over 100 years. Ever before I was born, my father also practiced before the First Circuit for many years. So that is what we know. We know the law of the circuit. We're proud to be part of the First Circuit. The First Circuit likes Puerto Rico, and particularly in November and February of each year, it historically has had a sitting in Puerto Rico. I cannot reckon why, but I'm proud to be part of the First Circuit.
Well, we would welcome you in the Second Circuit if it ever happened.
It is a very good circuit, and I'm also admitted to the Second Circuit, so.
Thank you.
Thank
Thanks,
you,
Mr.
sir.
Chairman.
Thank you, Senator Blumenthal. Senator Blackburn is recognized for 5 minutes.
Thank you, Mr. Chairman. And Judge, welcome.
Good morning.
We appreciate your being here. Just a couple of questions for you. Nan Aaron, President for Alliance for Justice, recently praised a number of President Biden's judicial nominations, including you, with the following statement. President Biden made an open commitment to promoting diversity on our courts, and he is honoring that commitment with these nominations. These are also judges who have a demonstrated commitment to equal justice, a refreshing change from the litany of Trump judges with records of turning the clock back on our rights. So I want to ask you this. Is it your opinion that the more than 200 federal judges nominated by President Trump, confirmed by the U.S. Senate, and currently sitting on the bench include a litany of judges with records of turning the clock back on the rights of Americans?
Senator, I have been a judge, now, a federal judge, for now 20 years. And as a judge, the role I partake is to uphold the Constitution and laws of the United States in every case that comes before me. As a judge, or confirmed as a circuit judge, I would sit with judges appointed by different presidents. In my particular case, if confirmed, I would have been appointed by two presidents, President Bush at the district level, President Biden at this level, at the appellate level. And as a judge, and from my experience sitting on the circuit with other judges, judges do exactly that. They follow the law, they follow precedent, they apply the law to the facts of each case, regardless of who appoints them.
So it is not your opinion that this is a litany of judges that are there to turn the clock back on Americans' rights?
Senator, that as a sitting judge, I cannot answer that precise question, but based on my experience, judges are judges regardless of who appoints them, and they have to do the same thing, and that is follow the law and apply precedent. and not make laws. They apply the law.
All right. 2006, when you went through your district confirmation, Senator Coburn asked you whether you had a judicial philosophy, and you responded, "I do not have a particular judicial philosophy. My own philosophy is to work as hard as I can and to apply the laws and Constitution of the United States at the trial level. That is what we do. We are not there to make new laws, to enlarge the Constitution or abridge the Constitution. That is the Supreme Court's role. We have to follow precedent from not only the Supreme Court, but also the First Circuit. This seems contrary to your very prolific work on U.S. territorial constitutional law since you've taken the bench." And Senator Grassley talked with you a little bit about this with the insular cases. As you say, that is the law of the land despite their imperialistic and racial underpinnings. In an article for the Federal Lawyer, you again criticized the Supreme Court's handling of the insular cases, noting that the Supreme Court's interpretation of its own concocted doctrine has been fraught with irreconcilable inconsistencies. And you continued to criticize the insular cases in your book, The Constitutional Evolution of Puerto Rico and Other U.S. Territories, a book, by the way, that you authored while sitting as a federal judge. In Chapter 3 of this book, you describe the insular cases as and I'm quoting you, "a doctrine of pure judicial invention with absolutely no basis in the Constitution, and one that is contrary to all judicial precedent and territorial practice," end quote. If you are confirmed to the First Circuit, will you follow the precedent of the U.S. Supreme Court?
Senator, I will do that if confirmed to the First Circuit, and I have followed in cases before me the President of the Supreme Court, always.
Would you like to update your response pertaining to judicial philosophy?
Senator, my philosophy, and Senator Coburn asked me that question. I said, I don't have a philosophy, but he did say after your quote, you do have a philosophy, and I agree. And my philosophy is to work as hard as I can and to apply the laws and Constitution of the United States to cases that come before me and follow precedents.
Okay, let me ask you this. Is it unusual for a sitting judge to author a book about cases or issues that are coming before him?
Senator, the book I wrote is based on historical facts and history. It does not touch upon, and I've been very careful because I know I'm a sitting judge, it does not discuss cases that could come before me or the outcome of those possible cases. I have been very careful to follow the Code of Judicial Conduct when writing that book.
Thank you so much.
Thank you, Senator.
Mr. Chairman.
Thank you, Senator Blackburn. Senator Whitehouse is recognized for 5 minutes.
Thank you, Chairman Ossoff. Good to see you in the chair. Welcome, Your Honor. Good to have you here. I think I'm the only First Circuit member on the panel, so this is terrific news for me to see you nominated by President Biden. And you'll have the terrific occasion to join what I think is a outstanding circuit. And I really look forward to having you there. I'm just delighted.
I concur with you. It's an outstanding circuit, Senator.
Yes. And the Rhode Island member is Rosary Thompson, as you may know, who I recommended to the president for that position, along with Senator Reed. And I think she'll be a wonderful colleague for you. And nobody else in the committee will know or care about this, but Suffolk University has been a very important law school for Rhode Islanders, and I'm sure you had a great number of Rhode Islanders in your classroom. So if you don't mind, we'll consider you a bit of an honorary Rhode Islander through your Suffolk credential.
I appreciate that. And when I went to Suffolk Law School, Rhode Island did not have a law school, so that's...
Correct. You were kind of
Rhode Islanders went to Suffolk.
Yes. But now we have our own, and it's a very, very good one. Roger Williams University School of Law. I commend it to anyone interested. So, two questions. The first is a legal question, and it relates back to the question of qualified immunity. Is it true as a factual matter of legal doctrine that the qualified immunity doctrine interrelates with other doctrines, including sovereign immunity, the Monell case doctrine, the Bivens case doctrine, and that they interact with one another?
In my experience in Puerto Rico handling civil rights cases, they are usually raised in the same cases that come before me because there is sovereign immunity many times for the state, but the officers are sued in both personal and private capacity, and qualified immunity will apply. The officers or government officials, doesn't have to be police officers, it could be government officials acting in any capacity. It is a doctrine that is frequently raised. And I do want to say it's not only, most people think it's only in the police context, but you can have a government official, a head of an agency who fires individuals based on, let's say, political patronage, and then you can raise the doctrine. It may apply, it may not apply, depending on the particular case.
And the reason I asked you that question is to highlight for my colleagues that I think we have an opportunity to clear up this area of law in the current reform that is proceeding by solving not only qualified immunity, but also, in essence, applying the ancient doctrine of respondeat superior throughout the system and eliminating what are really arbitrary distinctions between municipal, state, and federal law enforcement agencies with respect to civil liability. And I hope that we will take this opportunity to do that. The second question I have for you, Your Honor, has to do with juries. One of the things that we have seen in the Supreme Court has been a fairly persistent set of decisions that have raised the bars for plaintiffs to plead their cases in federal court, discouraging certain types of cases from being brought in federal court, undoing or restricting certain types of jury determinations regarding damages in federal court. And that is in some districts added to by pressure to settle cases rather than take them to trial. And the result has been described as a real crisis in jury trials in federal courts. We meet every year with my state judges in our district court, with Judge Smith, Judge McConnell, and Judge McElroy. And there was a time when they hadn't had a civil trial in a year because lawyers were discouraged from going to federal court and they had an exclusively criminal docket. I don't know what the situation is in Puerto Rico, but my feeling is that robust jury trials are a very important part of American democracy. If you go back to the founding days and to the Constitution itself, the importance of juries and jury trials had great significance in the governance that the founders were trying to establish and in the principles that we fought a Revolutionary War over. And so it's sad to see the institution of the jury trial kind of wither on the vine. And I think it can be made more robust. There are judges who are going out of their way to make it more robust, I think successfully. And I'd like any comments you may have on that situation.
Senator Ossoff, I know the red light is on, but if I could answer the question.
Of course.
Senator Whitehouse, in Puerto Rico, in the federal court, there are a large number of jury trials, civil and criminal, conducted every year. One of the reasons is that at the state level, the local level, particularly in civil cases, there is no right to jury trial in civil cases. So attorneys try to go through diversity or federal question jurisdiction to the federal court. I'm a true believer in the jury system. I've had, as my Senate Judiciary Questionnaire notes, I have presided, I believe, over 64 jury trials over the years, a few more when I was a magistrate judge, and it is a very important role that the jurors play.
Indeed. Thank you. Thanks, Chairman.
Thank you, Senator Whitehouse. Senator Lee is recognized for 5 minutes.
Thank you, Mr. Chairman. Thanks for being here, Judge Gelpi. There has been some conversation today already about the criticism that you've leveled on the insular cases, which of course deal with the relationship under our constitutional system between the United States and Puerto Rico. I want to make sure that I understand your position on the insular cases. Is it your view that the United States Supreme Court could give Puerto Rico immediate statehood by overturning the insular cases?
Senator, I have never spoken about that issue. The issue of statehood is a political question that it's up to the Congress to admit new states.
Okay, so the Supreme Court couldn't do that?
Well, as a sitting judge, I cannot answer that question, but I can answer that historically, it has always been up to the Congress to admit the new states.
Okay.
In the case of Alaska, Hawaii, which are two last states, and historically before, that's the procedure. It's been the Congress, not the Supreme Court.
Okay. You're not aware of any provision of the Constitution or any precedent suggesting the Supreme Court could do that?
I am not aware of any precedent from the Supreme Court, from any court of appeals, from any district court, or from any treatise or commentator. I have this is the first time I've been asked that, and I've studied the matter, but I've never heard of that before. So.
What effect would overturning the insular cases have?
Senator, that is a question that if the insular cases are no longer in effect, it is a matter that would come. Only the Supreme Court can overturn the Supreme.
No, I understand that. Yeah, that's not in dispute. You've criticized the insular cases a lot, so I want to understand what practical impact it would have if we were to overturn the insular cases.
Senator, that is a Puerto Rico, and I will say the case of Puerto Rico would still continue to be a territory. So whatever prospective relationship with or without the insular cases Puerto Rico has, it's a political question that will be dealt by the United States Congress.
Okay. Let's talk about your judicial philosophy for a moment. You've stated repeatedly in response to other questions by my colleagues, both today and in your previous confirmation proceedings, that you don't have a judicial philosophy. But then you've described some other roles that you think a judge does play and should properly play. I want to make sure that I understand your thinking about this, regardless of whether we call it a judicial philosophy. Do you believe that the original public meaning of a statute or a provision of the Constitution should govern, or do you believe that the meaning of the Constitution's text or a statutory text changes over time after it's been enacted or incorporated into the Constitution?
Senator, originalism is one of the ways to interpret statutes and the Constitution, and the Supreme Court has done that in several areas, such as Second Amendment, the Confrontation Clause, just to give you some examples. And in those particular areas, and there will be cases that could come before me or other courts that there may be analogous areas, but originalism has been recognized by the Supreme Court, and as a judge in the areas originalism applies, I have to apply originalism.
Okay, so where would it not apply? Where would you not want to apply the original public meaning of a statute, for example?
Senator, let me give you an example where the Supreme Court has not applied it, and it's basically in the Fourth Amendment search and seizure context. And the most recent example I can think of is the instance of cell phones. If under an originalist approach, there were no cell phones when the Founding Fathers were drafting the Constitution, the Bill of Rights, but the Supreme Court in 2018 recognized that cell phones are protected under the Fourth Amendment. And that is a departure from originalism, but is a departure that applies, and as appellate judge, and as a district judge, appellate judge has confirmed, I have to apply. So there are going to be instances where the Supreme Court has told judges to go on a separate route. But I would always follow precedent, if it's originalism or it's any other type of precedent.
Oh, sure. Obviously, you follow precedent, but still there will be lots of instances. You will constantly be addressing issues of first impression, or at least issues where there's no controlling Supreme Court precedent, or perhaps even any First Circuit precedent. In those circumstances, under what circumstances would you depart from the original public meaning from a statute after it's been enacted, or the original public meaning of a provision of the Constitution? I can point to myriad examples of where courts have departed from it, and it's resulted in disastrous consequences. I mean, Dred Scott and Korematsu were both examples of where the court departed dramatically from the original public meaning, with dire consequences to civil rights and civil liberties in America. Under what circumstances would it be appropriate to disregard the original public meaning?
Senator, if it's a case of first impression, I have to look to originalism. I have to also see if it's an area sort of, for example, analogous within the Fourth Amendment, the cell phone issue. So, for example, and you look to similar precedent and determine whether originalism has to be applied. And again, the Supreme Court has analogous cases suggesting you have to look to other tests.
Yeah, I have exempted that out by explaining I'm not talking about a case bound by precedent. I'm talking about where you're construing statutory or constitutional text not governed by precedent, and you have to figure out what it means. Within that framework, when would it ever be appropriate to depart from the meaning as accepted by the public at the time of enactment or adoption into the Constitution?
Senator, if it's a case of first impression, I have to look to see if it's in an area that precedent, even though not in that particular area, but analogous precedent suggests otherwise or not. And I have to be very careful, and it would have to be on a case-by-case analysis. In a vacuum, I cannot say in every case originalism doesn't apply, or in every case originalism doesn't apply or applies. So it's a case-by-case analysis, but originalism is a tool that the Supreme Court has adopted and applies to cases. So I do recognize it is one of many tests that I have to apply.
Senator's time has expired.
I see my time's expired. I would note here it's troubling that you can't answer that by saying it would not be appropriate. Look, bad things happen when we allow judges to impose their own will after a statute or a constitutional provision has been adopted. It subverts the will of democratic self-government. When we elect lawmakers to make these laws, and then judges after the fact change the meaning of it to mean something other than what they meant at the time, the generally accepted public meaning at the time, I don't know why that one couldn't be answered in one word. Thank you, Mr. Chairman.
Thank you, Senator Lee. Senator Hawley is recognized for 5 minutes.
Thank you, Mr. Chairman. Judge, congratulations on your nomination. Thanks for being here. I want to come back, if I could, to a question that Senator Whitehouse asked you about qualified immunity. This is a judicial doctrine, among other things. Are you of the opinion that qualified immunity doctrine needs to be revised?
Senator, as a sitting judge, and if confirmed, I will continue to be a sitting judge at the appellate level, that is a matter for me to apply the law as it currently stands. It is revised by Congress or it's revised by the Supreme Court. I will apply whatever the law is.
It's not for you to revise, is what you're saying.
It is not for me to revise.
And you'll faithfully apply the precedent as it currently exists.
I will, sir.
Very good. Let me ask you a follow-up on what a question Senator Lee just asked you. I want to make sure I'm just crystal clear on this. He asked you whether the Supreme Court could admit new states. You started by saying you couldn't answer that question. I don't think that's your position. So let me just try again for the record. Can the Supreme Court of the United States, through its holdings or judgments, admit new states to the Union?
Senator, there is no precedent for that. So if I could answer that way, that's my answer.
Okay. There's no precedent for it, but is it permissible under the Constitution? I mean, this is a matter of, if it came to you as a matter of first impression, whether or not the judiciary could admit new states?
Well, if you read the Constitution, it's the Congress that admits the new states.
Okay, good. Let's come back to the question of how you would interpret a statute, how you would proceed in a case where you have no controlling precedent on point from the United States Supreme Court or from your own circuit, should you be confirmed. You have no controlling precedent on point. You've got to interpret a statute or a piece of the Constitution, again, where there's no controlling precedent. Walk me through how you would approach that. Let's take a statute. Let's just focus on that. How would you approach it? No controlling precedent. How do you move through the process?
Well, the first thing, Senator, that any judge will do when interpreting a statute, you look to its plain text. That would be step number one. Ideally, that will resolve the entire matter. If the text is clear, there's no issues, and you apply that statute to the facts of the case and resolve the case.
In the case when the text is ambiguous?
Where the text is ambiguous, you have to go to legislative history. And if that does not resolve the matter, you may not have precedent on that same particular statute, but you have to then look for analogous precedent. And let me give you one example. Title VII of the Civil Rights Act has been applied and interpreted by courts for many years. Years later, the Age Discrimination and Employment Act was enacted, and the precedent was that it should follow the same framework for ruling on the cases and applying the statute because they're similar. So you have to look perhaps to similar statutes, case law from my circuit, of course, but sometimes there's case law from other circuits. It's not binding precedent, but you have to look to see how everybody has been resolving the matter. And
So this, I think, gets us into the realm that Senator Lee was just talking about. What I don't hear you saying is that in the situation where the text is not plain on its face, where there isn't an obvious agreed upon meaning, what you didn't say is I would look to the original public meaning of the text at the time it was enacted. So in other words, I would look and see, well, when Congress or the state legislature or whatever, whoever enacted the statute, when they enacted it at the time, what was the public meaning? You didn't say that. So is that not something that you would consider?
Senator, if new statutes are enacted, it's the original public meaning also can be considered for the statute. And that is something that, for example, if Congress enacts a statute today or tomorrow, it is easier to follow those statutes and apply those statutes because the public meaning is usually going to be evident. And there's going to be statements also from the senators and the congressmen who enact that law.
But what if a lot of the statutes that you'll be called upon to apply, of course, and you know this, you've been on the bench, you do this every day, many of the statutes you'll be called upon to apply are decades old. And the legislative history, maybe it exists, maybe it doesn't, maybe it's ambiguous. So in the case in which you have a statute that you're trying to interpret, the plain text is disputed, and the litigants say, no, the plain text means this. Oh, no, the plain text means that. It's disputed. The statute is older. What do? How do you proceed? No precedent on point.
Well, Senator, original public meaning is one of the ways to interpret the statute, same with the Constitution. And again, I have to look at precedent, but that is also something I have to look at definitely.
So this gets at the question of your judicial philosophy, which is just another way of talking about your approach to statutory interpretation, to constitutional interpretation, to the role of the judge. I have to say I'm a little bit worried by what I'm hearing in response to Senator Lee and in response to the questions I'm asking you here. It doesn't seem to me that you actually would prioritize the text, its meaning. I don't hear any discussion about the methods for finding that meaning. There's a lot of talk about precedent. I understand that. But of course, if you're confirmed to this role, I think you're going to find yourself dealing with cases where you don't have as much precedent on point. You're going to have cases of first impression. And in those cases, the Supreme Court of the United States has clearly instructed that text is to be the first and primary consideration, and then ascertain the historical meaning of the text. I mean, there's lots of Supreme Court precedent on point. So I'll have some additional questions for you for the record to try and nail this down and make sure I really understand where you're coming from. Thank you, Mr. Chairman.
Thank you, Senator Hawley. Senator Kennedy is recognized for 5 minutes. Senator Hirono, do you wish to ask a second round of questions?
Oh, I'm sorry. I didn't know she'd had a first round. I apologize.
So I would like to make a comment after the Republicans go. So
Senator Hirono is
please.
recognized.
No, I think Senator Kennedy should go first because he hasn't.
I think it was my turn.
It is.
I thought you had yielded to Senator Hirono. Senator Kennedy, you're recognized for 5 minutes.
I didn't know that Senator Rono had a first round.
There you go.
No problem. Please proceed, Senator Kennedy.
Okay.
Thank you. There you go.
Judge, I'm still uncertain about your answer. Can the United States Supreme Court, on its own, admit a state to the Union?
Senator, as I answered, the Constitution of the United States.
This is a real simple question. Can the United States Supreme Court on its own admit a state to the Union?
I understand the answer is no.
Okay, thanks. Appreciate that. Do you think the federal judicial system is systemically racist?
Senator, I have had, as a sitting judge for 20 years, I have had cases that come before me involving allegations of racism. I have presided over those.
Yeah, but I'm asking about the federal judicial system. Is it systemically racist?
Well, Senator, judges apply the Constitution and laws, and we cannot, if you're asking about if judges are racist or the judicial system itself, we apply the laws, but we do not, a judge cannot take race into consideation.
Well, but do you think the federal, you know what systemic racism is? I mean, it comes up every day now in America, and do you believe that the federal judicial system is systemically racist?
Well, Senator.
You've been a part of it.
Yes, I can give you an example that the Congress and the Sentencing Commission.
I appreciate an example. I'm just trying to get an answer. Do you believe it's systemically racist?
Senator, that's a question I cannot answer.
You're a sitting federal judge right now?
I am a sitting federal judge.
How long have you been a federal judge?
20 years.
And you've heard these allegations that all our institutions are systemically racist, and after 20 years you haven't drawn an opinion?
Senator, I can tell you, in my court,
But you don't have an opinion about whether the federal judicial system is systemically racist after 20 years?
Senator, I have to say no.
You think it's not, or you don't have an opinion?
In my experience.
Wait, let me understand your answer. You think it's not systemically racist, or you don't have an opinion?
No, I don't have an opinion.
After 20 years?
That is correct.
And you want to be on the Court of Appeal?
Senator, yes.
Okay. All right, what's your definition of justice?
Justice, Senator, to me, means that the law is applied equally to all individuals, regardless of race, sex, position, and that all cases are heard by a fair and impartial judge, fair and impartial jury, and that the laws are applied equally.
Okay. How do we know what is your barometer for deciding whether a law that's being applied equally is just?
Well, as a judge, I have cases that come before me, individual cases.
I'm not asking about a case. I'm asking about philosophy.
Well,
how do you just personally look at a law and determine whether that law, in your judgment, is just?
Well, it is not for a judge to determine whether a law
I'm not asking
is just
you as a judge. I'm asking you just as a person. I'm trying to understand you as a person.
Well, Senator, whatever understanding I have, if a law is just or not just, I have to apply that law.
I know. Let me stipulate that, okay? Let me stipulate that. I'm not going to ask you how you rule on a case, and I know you're going to follow precedent, okay? You're always. I get that. How do you personally look at a law and decide whether it's just or not? Pretty basic.
Well, Senator, that is not the role of a judge to determine if a law is.
No, but it's the role of a human being. I'm just trying to get to know you. Do you have a personal definition of justice?
Well, Senator, justice, in my particular case.
I know it's applied equally, but how do we know a law is just or unjust, in your opinion?
Well, Senator, as I mentioned, I have to apply the laws as they stand, and I have to make
Okay,
sure
let's
that
move on, Judge. I don't think you're going to answer. Do you think, let me ask you about crime. You've sentenced people?
Yes, Senator.
Do you think crime is a disease that needs a cure? Or do you think it's antisocial behavior that deserves punishment?
Senator, as a judge, and I've been sentencing felony defendants for 15 years as a U.S. district judge, I've always followed the sentencing statute. And
I'll stipulate that.
And I have to.
But I'm asking you about if a person commits a crime, do you see it as a disease that needs to be cured, or do you see it as antisocial behavior that merits punishment?
Senator, each individual defendant has to be sentenced individually. I have had individuals who are antisocial, and when you look at the pre-sentence reports, you sentence them accordingly. You have career offender, criminal. You have other individuals who have.
Judge, I can't vote for you if you won't answer my questions. I hate interrupting you, but these are pretty basic questions that I would expect somebody who's been on the federal bench for 20 years to have thought about.
The senator's time has expired. Judge, if you wish to respond, you have that opportunity.
Senator, as a judge, every time I sentence an individual, and I do this on an individual basis, I consider the nature of the offense, aggravating factors, mitigating factors, the person's individual personal history, his criminal record, and also consider the sentencing guidelines. And I apply that exercise on a case-by-case individual.
We both know that.
Thank you, Senator Kennedy. Senator Hirono is recognized for a comment.
Thank you very much. There were a lot of questions asked of this nominee relating to originalism, and the way I see it is this was an effort to get Judge Gelpi to acknowledge originalism as the only way to do either constitutional or statutory interpretation. He did not allow himself to be boxed in this way. And we all know that statutory interpretation, there are canons of construction. We all learned that in law school. And then as for applying originalism in the constitutional context, if originalism were applied, I think that Obergefell, for example, that protects same-sex marriage would not have been decided in that way. And in fact, it's one of the reasons that Justice Scalia was a dissenter in that case, and one of the reasons that both Justices Alito and Thomas have indicated that they would like to revisit Obergefell. And if originalism were applied, I would say that that really puts into jeopardy the decision in Roe v. Wade, which protects a woman's right to choose. So all of this effort to try to box this nominee in is seen for what it is as far as I'm concerned. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Cruz is recognized for 5 minutes.
Thank you, Mr. Chairman. Judge, congratulations on your nomination.
Thank you, sir.
As a sitting federal judge, you wrote a book entitled The Constitutional Evolution of Puerto Rico and Other U.S. Territories. In that book, you're highly critical of the insular cases, a series of opinions from the Supreme Court in 1901 that addressed the application of the Constitution to territories where the United States exercised sovereignty. Specifically, you describe these cases as, quote, a doctrine of pure judicial invention with absolutely no basis in the Constitution and one that is contrary to all judicial precedent and territorial practice. Later, in 2011, you concluded a Spanish-language academic article on the insular cases by saying, quote, it is now the hour, and indeed it has already grown late, for the Supreme Court to re-examine and remedy this offensive and obsolete judicial dilemma, which we have had to tolerate for more than 100 years by over 5 million American citizens who live in Puerto Rico and other territories of the United States. I take it then, based on your writings, that you believe the insular cases were wrongly decided.
Senator, yes, when I wrote in those academic books about the insular cases, I've discussed it from an academic perspective, and I've made reference to the fact, particularly, that the insular cases were decided by the same Plessy versus Ferguson Supreme Court, and that they considered racial, ethnic, discriminatory matters, and the same Supreme Court took that into account. Those are matters that nowadays I don't believe any member of any branch of Congress, of the government, would take those matters into consideration. So that is my criticism of the insular cases. In cases that I've had before me, I apply the doctrine as it still stands. That is the law of the United States, whether I like it or not.
So you've said you believe the insular cases were wrongly decided. Do you believe Brown versus Board of Education was rightly decided?
Senator, I believe it was rightfully decided, yes.
Okay, what about District of Columbia versus Heller?
Senator, that is a case that is the law of the land. I have to apply Heller, I have to apply McDonald, and it is the Supreme Court doctrine which I will apply.
Well, I understand that, but that was not the question I asked you. You just told us you believe the insular cases were wrongly decided. You just told us that you
Not the insular cases. Oh, yes, excuse me, yes, sorry.
that that you believe the insular cases are wrongly decided. You just told us that you believe Brown versus Board of Education was rightly decided. So I'm asking you what your views are on Heller versus District of Columbia. Was it rightly decided or wrongly decided?
Well, Senator, as I mentioned, that is the law of the land, and I am aware that there are other challenges that will be upcoming, and there's one in California. That similar challenge could be before my court or the Court of Appeals. So that is something that, as a sitting judge, and that is a controversy that is live and ongoing, so I should not decide that. But I will apply Heller and McDonald. I can guarantee you that.
Well, you were a sitting judge when you wrote about the insular cases, correct?
Senator, yes, I have criticized historically the underpinnings of the insular cases, but
Well, not just the underpinnings. You said flat out they were wrongly decided and the Supreme Court should reverse them. That was not just an academic observation. That was calling a decision wrongly decided and saying it should be reversed.
correct, a decision based on racist underpinnings. I agree with you.
And Brown versus Board of Education, certainly questions about race and litigation about what equal protection under the laws means. That litigation continues in courts across the country today. Is that right?
Not the Brown holding.
But the principles on which Brown was decided, those are actively
There are
litigated issues.
particular equal protection cases filed in federal courts every day. That's the purpose of federal courts.
So how about the Citizens United case? Was that wrongly decided?
Senator, that is the binding precedent, and that is something that I could have a similar case in the future. But again, that is the law of the land. I have to apply it.
So it seems on cases where I'm not clear what your standard is for when you will answer what questions were wrongly decided, what cases were wrongly decided, and what cases were not.
Well, Senator, I can tell you, historically speaking, Brown, I can say, was correctly decided. The insular cases, historically speaking, the rationale behind those cases was based on racist underpinnings. I have to say that rationale was incorrectly decided. As a matter of
So
history.
Senator Hirono just offered a defense of you, saying that you refuse to commit to originalism because originalism would prevent outcomes that she supports. It would prevent outcomes in cases like Obergefell and Roe versus Wade, and because she supports those outcomes, she doesn't want judges who will follow the original understanding of the Constitution. Is that how you would articulate? Well, is it right that you don't intend to follow the original understanding of the Constitution?
The senator's time has expired. Judge, you may answer the question.
Senator, as I mentioned to an earlier question, I will apply originalism, and that is one of the factors or the tests that the Supreme Court has laid out for judges to follow, and I cannot ignore it. I have to follow originalism in the cases where it is appropriate.
But do you agree with Senator Hirono's
Senator's time
defense
has
of you
expired.
that those are the reasons?
The senator's time has expired. Senator Padilla is recognized for 5
You know,
minutes.
this is a committee where we've had a little bit of comedy, and I recognize
Chair.
that Senator Ossoff is
time.
new, but we
Chairman.
generally don't have the chairman trying to jump in
Point of
30
personal
seconds
privilege,
in.
Mr. Chairman.
Thank you,
And I
Senator.
recognize the chairman may not want these questions answered.
mine.
Point of personal
Thank you.
privilege, Mr. Chairman.
There'll be order in the Judiciary Committee. Senator Cruz, your comment is noted, and Senator Padilla.
Chairman,
Thank you,
point
Mr.
of
Chair.
personal
Thank you,
privilege.
Mr.
Chairman
Senator
Ossoff
Padilla,
desperately
out of
does not want
respect
these
to-
questions answered.
Point of personal privilege.
Senator Hirono.
I would request that my colleague, Senator Cruz, not misstate what I'm saying. And you know what? All this mansplaining, please stop. Thank you.
Senator Padilla is recognized for 5 minutes.
Thank you, Mr.
What
Chair.
was
Thank you
mischaracterized, Senator
to-
Hirono? You just said I
Gelpi.
mischaracterized something. What?
The floor is mine, Senator Cruz.
Senator
The floor-
I'm
Padilla
very
is
proud you have a
recognized
gavel,
for 5 minutes.
but a point of personal privilege, Senator Hirono just said I mischaracterized something she said. So I am asking her what was mischaracterized. You are welcome to explain what
Mr.
was
Chair,
mischaracterized.
Mr. Chair, is the floor mine?
Okay, so you're not going to explain
Senator
what
Cruz.
the claim was mischaracterized.
Everyone
Cruz,
bear
any
with me.
questions?
Senator Cruz, you may respond to Senator Hirono.
I described what Senator Hirono said. I asked the judge if he agreed with her defense that he should not embrace originalism because it would not allow him to reach outcomes that she favored. She's now come back and said that was a mischaracterization of what she said, and so I'm inquiring, what is mischaracterized?
Mr. Chairman, very briefly, because otherwise, you know, the thing with my colleague is he always has to get the last word, and that is a fact. But one of the ways mischaracterized is that I do not object to originalism as applied because it results in decisions that I don't agree with. I disagree with the way that the court proceeded in some of the members of the court and how they proceed with the originalism to get to the results that they want. So that's it.
Is it not accurate that you said you thought originalism
Mr. Chairman.
shouldn't be followed because it would lead to a different result in a Obergefell and a different result in Roe? Is that not what you said in this committee just a few minutes ago? Okay, well, the record is clear.
Some of the court members apply originalism, not all of them do, and that is why in some instances they have been in the minority.
Well, the
And
record
maybe not
is
so
clear
much
what you
now.
said, and now you're saying you didn't
Mr.
say.
Chairman, thank you.
Thank you for
your
this exchange,
indulgence.
senators, and Senator Padilla is recognized for 5 minutes.
Thank you, Mr. Chairman. And thank you to Mr. Gelpi for his patience. In 2006, this Senate unanimously confirmed you to serve as a federal district judge for the District of Puerto Rico. And since then, you've heard thousands of civil and criminal cases, issued at least 880 opinions, and presided over 60 jury trials. In short, you're an experienced hand as a district judge. Given your depth of experience on the district court, why do you want to become a judge on the Court of Appeal?
Good morning, Senator. Still good morning?
Still morning.
Well, I've been a judge in my legal career since I graduated from law school 30 years ago. I had the opportunity when I was a law student to see a lot of the arguments before the Court of Appeals for the First Circuit. My father actually was here with me, argued many of those cases. So over the years, when I was a law clerk, I really cherished and appreciated the role of the Court of Appeals. To me, that was amazing as a law student. So I would go sit through all our arguments. I always wanted to have a trial experience because aside from an appellate experience, but in all of my positions as a lawyer, when I was a federal defender, I did all my trial work, and I would always do my appellate work. And my colleagues who did not like doing appellate work, I would say, please hand me over the cases, because I really liked the dynamics of the appellate practice. When I was working for the Commonwealth of Puerto Rico at the Department of Justice and as Solicitor General, that was the bulk of my work, appellate practice. I've been on the district bench for 20 years. I love it. It's dynamic every day. I always go to work with a smile. I always come home with a smile. And I feel this is a vocation. It is something my way of serving our great nation. And I understand that based on the practice and experience I've had, and I sat on the Court of Appeals for many years, so you get more admiration having done that. And also, being part of the First Circuit, it is something that I would take as an honor and a privilege, bringing all of that experience that I've had to join a already experienced bench and to bring that perspective from Puerto Rico to the First Circuit, which of course encompasses other states.
Great. Well, you make a good case for how your experience gained as a district judge will inform your work on the circuit court. But I wanted to go back slightly further back into your career and your trajectory. After you graduated from law school and finished your district court clerkship, you chose to work as an assistant federal public defender for about 4 years. Is that correct?
That is correct, 3.5 years.
So the choice is notable because in the past it was often said that the surest way to become a federal judge is to first be a prosecutor. Yet you chose a different path. I'd like to change that seemingly conventional wisdom too, and you're a great example. But let me ask you, what was it that drew you to become a public defender, and how did that experience affect the arc of your legal career, including the time you spent, on the other side as a lawyer for the government?
Well, Senator, what drew me to work for the public defender was I had been a law clerk, so I had seen many criminal trials. I'd seen great prosecutors. I'd seen great public defenders. But what drew my attention at that time was that I recognized that I would be serving a constitutional role in representing clients. And when I interviewed, I was told, you're going to have some very good clients, you're going to have some very bad clients. But to me, it was very important because every single client that I had, I represented him or her to the fullest. I ensured he or she was guaranteed every constitutional right, every benefit of the law, and that is it's the important thing of being a public defender. You also have to deal not only with your client, with their families, you also learn how to deal with the prosecutors, particularly when the law favors the government, and that is why criminal laws are enacted. But it was a very dynamic experience, so having gone through that experience, it is something, same with representing the government. It's a total opposite dynamic, but at the same time, you work as part of a larger justice system, each person as an advocate. As a judge, I've taken those experiences and into my judicial, as part of my judicial background, and I'm very aware of the roles of prosecutors, defense attorneys, when they come before me, and I've done that for 20 years.
Thank you very much.
Thank you,
Mr. Chair.
Thank you, Senator Padilla. And thank you, Judge Gelpi, for appearing before the committee today. That concludes our questioning. Please be mindful that senators may submit written requests for additional answers following the hearing, and we'd ask that you work diligently to respond to those requests. And with that, we will move to our second panel. I'd ask for everyone's patience for a moment as we finalize the setup for these next 4 nominees. Thank you, Your Honor.
Thank you, Senator, and thank you, Senator Grassley, and Senator Hirono, and Senator Padilla, and everybody else that was here. We will now hear from our next 4 nominees, and before making your opening statements, I would ask that the nominees please stand and raise your right hand to be sworn in. Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. And Judge Kelly, you may proceed with your opening statement. I believe you need to toggle your microphone, Judge.
Okay.
There we go.
Good morning, Senator Ossoff. Thank you for chairing this hearing. I'd like to thank Chairman Durbin and Ranking Member Grassley for including me in today's panel. I wish to thank publicly President Biden for nominating me to the U.S. District Court for the District of Massachusetts. I am truly humbled by this high honor and President Biden's faith in me. Also, I wish to thank my home state senators, Elizabeth Warren and Ed Markey, for their kind remarks and having the trust and confidence in me. Thank you to the bipartisan committee who forwarded my name to the senators. First, I want to acknowledge my mother and father who are no longer with me physically, but always in my heart. Through their life lessons, my parents taught me to be resilient when faced with adversity, to live an honorable life, and to adopt a work ethic that does not permit excuses. I know I would not be here before this committee if it was not for my parents and all those who contributed to my life's journey as role models, mentors, supporters, and uplifters. Some of my supporters and uplifters are here with me today. Introducing first, Mrs. Elsie, who traveled from California to be here in place of her daughter, Gina Elsie, who we lost 9 months ago. Gina was my best friend at Georgetown Law Center, and I know she's here with us now. Also joining me from Georgetown is another dear friend, Alexis Taylor. Naomi Thompson and her mother, Mrs. Cabral, are also present. They represent the Massachusetts contingent. Naomi Thompson is my best friend from Colgate University. I am doubly blessed to have two mother figures with me today. They counsel me and comfort me like my mother would. Representing my birth state and New York contingent is my best friend, Darlene Jarif Mangani. We began our legal careers together at the Legal Aid Society. Thank you to those who could not be here but send their love and support, like my brother in Texas, other family members, friends, and colleagues. With that, Senators, I thank you again for this invitation to appear before you and welcome your questions today.
Thank you, Judge Kelly. Ms. O'Hearn, you may now also proceed with your opening remarks.
Good morning. Thank you. I would like to thank Chairman Durbin and Ranking Member Grassley for scheduling this hearing, Senator Ossoff for chairing the hearing, and the entire committee for considering my nomination. I would like to thank Senators Menendez and Booker for recommending me to the President, and Senator Menendez and Booker also for their kind introduction this morning. I would like to thank President Biden for the honor of nominating me to serve in this important position. First, I would like to recognize my parents. My mother, Charlene Steinmetz, is a retired public school teacher. She's unable to be here today, but is watching from home. I appreciate her love and support. I'd also like to recognize my late father, William McCall, who was always there for me and gave the best advice. I would like to introduce my two children who are here with me today. My daughter, Jessica, is a recent graduate of Widener Law School. She's completing a clerkship, and I know she will be an excellent lawyer. My son, Robert, is a graduate of Marist College and works for a global aerospace company as a systems integration analyst. He has the most extraordinary work ethic, and I'm so proud of the young adults they have both become. I would next like to introduce my law partner and mentor of nearly 30 years, Bill Tambusi. Everything I know about being a lawyer, I learned from watching and working with Bill. Finally, I would like to introduce two of my closest friends, the Honorable Sherry Schweitzer and Susan Lemming. I thank them both for their friendship and for being here. There are many other friends, family, and colleagues who could not be here today and who are watching from home, including my brother Bill and his family. I thank them for their support during this process. I would like to especially recognize my Brown and Connery family, the law firm where I've spent my entire career. Thank you, and I'm happy to answer any questions you may have for me.
Thank you, Ms. O'Hearn, and Ms. Greenfeld. Please proceed with your opening statement.
Thank you. Thank you to Chairman Durbin and Ranking Member Grassley for arranging this hearing today, and to you, Mr. Chairman. And if I may, I'd like to thank all the staff. As a former staffer, I know how hard they work to put these hearings together. And a truly heartfelt thank you to my former bosses, Senator Leahy and Senator Hirono, for introducing me to the committee today. It was my time working for each of them that taught me to love the Senate, understand its history, and respect its responsibilities. After so many years sitting behind senators and witnesses, it is strange for me to be sitting on this side of the table, but having Senators Leahy and Hirono speak for me today makes me feel at home. I'd like to introduce my family with me here today, my husband Richard, my children Jake and Abby, as well as my mother Ruth and sister Susan. Watching from home are my sister Jennifer, my brothers and sisters-in-law, my mother-in-law, and other extended family. I'd like to thank them for their love and support. My dad, who passed away almost 5 years ago, cannot be with us, but if he were, he would be the first one to brag about this to every stranger he met. 82 years ago, when my grandparents fled Nazi Germany with their 2-year-old, my mother, got off a boat in Hoboken, New Jersey, and headed for Baltimore, Maryland, they could not have dreamt that their granddaughter would have the great honor of being nominated by the President of the United States to a position working for the Attorney General of the United States, and I know they would be proud. My grandparents and my mother's life journey, escaping the Holocaust and finding a home in the United States, led to my interest in studying law and in public service. From a young age, I understood that the United States, a country founded and dedicated to the rule of law, gave my family refuge, and I wanted to be a part of that system. And I have been very lucky to do that over the course of my nearly 30-year career, serving 8 years as a Senate staffer in the Judiciary Committee, going on 13 at the Department of Justice, During that time, I came to appreciate the complementary powers and responsibilities of the executive and legislative branches, which require close communication and a spirit of dynamic compromise. The American people expect and deserve no less. If I am confirmed as Assistant Attorney General for Legislative Affairs, I will do my best to lead the proud professionals of OLA to ensure that the Department of Justice supports you completely in fulfilling your role under the Constitution.
Thank you, Ms. Greenfeld. And finally, Mr. Schrader, your opening remarks.
Thank you, Senator Ossoff. And my thanks as well to Chairman Durbin and Ranking Member Grassley for organizing this hearing and for the honor bestowed on me by President Biden with this nomination. With your permission, I'll just briefly introduce my family who was with me today. My wife of 45 years, Catherine Bartlett, two of my three children, Dr. Emily Schrader and Ted Schrader, and my daughter-in-law, Catherine Turner. We're missing our youngest, our third child today, who is home in Newton, Mass, taking care of a newborn who's 1 week old, 1 week and a day. She makes the sixth of our grandchildren, none of whom made the trip today and may be watching today, but who are probably climbing the walls, doing other kinds of things with their time. I will just say, if I am fortunate enough to be confirmed by the Senate, I would be returning to an office that I served in the Clinton administration. I think I have a real appreciation for the role and responsibilities of the Office of Legal Counsel. It's not a policy-making office in the Department of Justice. We assist in the legal interpretation tasks of the Attorney General, providing advice to the executive branch in the most competent, even-handed, impartial, and objective way that we can in order to help contribute to the important work for the country of bringing to life the ideal of a rule of law in which all individuals are created and treated equally, and in a system of the administration of law that follows those precepts as well. So I am honored to be here today and happy to answer any of your questions.
Thank you, Mr. Schrader. Members will have 5 minutes to question this panel, and I'd like to begin with you, Mr. Schrader. At its best, the Office of Legal Counsel should develop what it believes to be the best interpretation of a statute and offer rigorously vetted advice independent of partisan pressure or personal interest that protects the separation of powers and ensures that executive action respects congressional prerogatives. Mr. Schrader, how will you ensure that the OLC operates according to these principles, and do you agree with the principles just stated?
Senator, I agree thoroughly with them, and I think they are fundamentally important to the work of the office. I also think the Attorney General has indicated the same expectations for the office as has the President. So the starting point is I will work for two bosses who are giving me exactly the same kind of instructions that you have just articulated. We attempt in the Office of Legal Counsel to observe a form of deliberation that ensures that all matters are thoroughly ventilated by both career and the political leadership in the office as thoroughly as time permits, but in many instances that is enough time, I think, to delve very deeply and carefully into the questions that are posed. I plan to implement the practices of the office that I think have worked best in the past to ensure that that kind of thorough deliberation is visited on every question that comes before us.
Mr. Schrader, during your career at DOJ and your past tenure at OLC, have you provided advice that perhaps you disagreed with personally or politically, but that you believed reflected the law?
Senator, I have. Perhaps can give you an example from the Clinton years, which have been explored in hearings, so before the House and the Senate, so they're matters of public record. This reflects work we did on something that we came to call the shoot-down opinion, which was a decision that we reached after being asked a question about whether, in connection with the war on drugs, some of our armed forces information about the location of small private planes coming out of South American countries could be provided to those countries to aid in the interception of those planes because they were delivering illegal drugs across the border into the southwestern states, landing and departing without enough warning for our law enforcement to apprehend them. So we attempted to establish a cooperative relationship with some South American countries who were being supportive of our efforts. We had to deliver the news that upon analysis of this program, which was a very high priority in the war against drugs, that it was quite likely unlawful, that it perhaps even worse, it exposed participants in the assistance in the possibility of being liable for aiding and abetting in the event that innocent people were harmed by actions by other countries on the basis of the information we were supplying, as in shooting down those planes. This was not received well because this was an important policy priority of the administration at the time, but it is an example that I can talk about in which we had to render advice that was not consistent with the policy positions being taken in the administration.
Thank you, Mr. Schrader. In addition to serving on the Judiciary Committee, I chair the Homeland Security Committee's Permanent Subcommittee on Investigations, also known as PSI. In the past, at times, federal agencies have been reluctant to provide PSI with documents concerning matters subject to ongoing litigation or federal investigations, which can impair the legitimate oversight prerogatives of Congress and of that subcommittee. Can you please speak, Mr. Schrader, to the advice or guidance that you'll provide to federal agencies facing congressional requests for information relevant to ongoing litigation?
Well, Senator, I understand the importance of oversight review by this body and the other body. I've worked for the Senate Judiciary Committee myself for about 4 years in the Reagan and Bush administrations, and I know how frustrating it is to make requests that are not timely complied with. At the same time, there are long-standing issues related to the disclosure of information that affects important law enforcement interests and ongoing investigations that have to be weighed as well in an equation about whether documentation is provided. I think the department is going to make every effort it can to accommodate oversight requests in all areas, but there may be situations in which the nature of the documents that are involved will be ones in which we are just going to have to agree to disagree.
Thank you, Mr. Schrader. Ranking Member Grassley, you're recognized for 5 minutes.
Thank you very much. Mr. Schrader, I'm going to start with you. OLC under President Trump issued an opinion relating to the Equal Rights Amendment and the current belated ratification process. It's unlikely that the current administration agrees with the previous one as a matter of policy on the ERA, but the law is the law. So, I'm not asking you how you would rule, but I'd like to know what factors would you consider in deciding whether or not to rescind that opinion?
Well, Senator Grassley, that specific opinion, I believe, is the object of litigation currently against the archivist, who has announced that he will follow the OLC advice, but he has also said he will follow whatever the final judgment of the court is in the case. So I would not come into the job under any circumstances with an agenda to look specifically at any prior opinion. But in this instance, in particular, I think we will be all best suited if we allow the litigation process to answer that question.
I agree with that part of it, but I'm only asking you what factors you would take into consideration to decide whether or not to rescind that opinion.
Well, what would be most important to me is if there was an ongoing request for legal advice that we had received in the office. The Office of Legal Counsel is a very reactive office. We don't have our own agendas. We answer questions that other parts of the executive branch have posed to us. So that would be initially, we would need, I believe, a request to look at that exact issue, which I doubt that we would receive because of the nature of the ongoing litigation.
Okay, let me go on. As you know, I'm a strong advocate for government transparency and congressional oversight. You've suggested that the Justice Department should have released more OLC opinions saying that, quote, Congress cannot exercise its governance responsibilities in regard to a problem if they don't know the problem exists, end of quote. Will you commit to transparency by releasing all of your opinions as an Assistant Attorney General for the Office of Legal Counsel in a timely manner to help Congress properly perform its oversight role? However, if you do not release an opinion, will you commit to ensuring that the public knows why that opinion was not released?
So, Senator, I'm a very strong advocate of transparency, as that quote from that you have read from me indicates. It is my intention to release Office of Legal Counsel opinions in a timely manner, and we will make every effort to do so. There are situations in which the requester may have requested confidentiality, and we have a relationship with the people who request opinions of us that we need to respect that judgment on their part, because people will stop coming to us for advice if we say we will be confidential and then we release the information. So that may present an obstacle on an individual case basis situation. But overall, I'm very much committed to the timely release of formal opinions of the Office of Legal Counsel. Yes, sir.
Well, then, in regard where maybe privacy or confidentiality is a issue, you could would you commit then saying at least you can't release it because of the confidentiality that was promised?
In that situation, we would make every effort to develop a method to make the basics of an opinion available to legitimate inquiries by the Congress.
Yeah.
How exactly that would take place, what form it would take, it would have to depend upon the circumstances of a particular case.
Yeah. Ms. Greenfield, on our call together that we had, I believe it was over the phone, I asked you about oversight and specifically about the lack of responsiveness from both DOJ and FBI to my oversight letters and requests. In your current role, you're responsible for responding to congressional oversight. Have you been instructed not to respond to any of my oversight requests, and if so, by whom?
Senator, my experience as a Senate staffer has given me tremendous respect for the role of Congress in conducting oversight. No one has given me instructions not to answer your requests. Indeed, the Attorney General has been very clear that we should respond to congressional requests, which we do every day. They come in through email, phone. We get requests for briefings, for technical assistance on legislation, and the vast majority of requests that we get are easily complied with. We are able to work on a bipartisan basis with many offices. Every once in a while, we do get more complex requests, and some of yours are among them. We have been working very hard to get responses for you when we can. We have members of the Office of Legislative Affairs are in conversation, very frequent conversation with your Oversight Council, trying to find ways that we can get you the very best answers we can.
My time has run out, so I've got 5 things that I'm going to submit to you in writing. I'd like an update on those 5 separate requests.
Yes, Senator.
Thank you, Senator Grassley. Senator Hirono is recognized for 5 minutes.
Thank you very much, and I'd like to thank Senator Klobuchar for her courtesy in letting me go first. I will not take up the full 5 minutes. I would just like to ask my preliminary questions of this panel. By the way, welcome to all of you, and a special aloha to Helene, of course.
Yeah, I'm going to go.
I will ask the 2 initial questions that I ask of every nominee, and I will ask the full panel. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature? Full
No,
panel,
Senator.
please.
No, Senator.
No, Senator.
Have any of you ever faced discipline or entered into a settlement related to this kind of conduct?
No,
No,
Senator.
Senator.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Cotton is recognized for 5 minutes.
Thank you, Mr. Chairman. Rising rapidly to the top so early. Us younger, newer members have to stick together. Ms. Greenfield, I want to talk about the case of Terry v. United States, which the Supreme Court recently handed down. It concerns convictions and sentencing for crack cocaine, specifically under the First Step Act. The United States had defended its conviction and sentence for this crack dealer, which is typical in these cases, even when the government thinks the verdict might have been overturned. That was not the case, though, here, since it wasn't even close. In March, while you were the acting assistant attorney general before your nomination, however, the department waited until the very last moment, I think the day its brief was due in the Supreme Court, and then sent the court a letter saying the department had changed its mind following the change in administration and would no longer defend the sentence. In fact, it took a step further and took the unusual step of confessing error, saying that it wasn't just going to stop defending the case, but rather it said the department had been wrong all along. This required the Supreme Court to appoint an outside lawyer to do the Department of Justice's job. Just last week, the court ruled unanimously in favor of the very position the department abandoned in March. Who decided in the department to change the department's position in this case?
Senator, I do not know. I presume the decision was taken in the Office of Solicitor General.
Were you aware of this case? Or the
No, Senator.
department's unusual behavior in the case for today?
I think I was aware generally from reading the news, but I was not involved in that.
So you and your office was not involved in the decision?
No,
to
the
change its
office,
position?
the Office of Legislative Affairs serves as, I would say, a conduit for communication between the department and the Congress. We take in questions from staff members, from members of Congress about enforcement schemes, about pieces of legislation that they want to author. We give technical assistance on those. We get letters that members of Congress send on behalf of constituents and on behalf of themselves, but we are not involved in any decisions about litigation.
Okay. I think the First Step Act was a disaster, and if the department proceeds in similar fashion in the future and you're confirmed, you should probably just go ahead and reach out to my office in advance, because you'll be hearing from us very quickly to get answers about these kind of matters. Mr. Schroeder, I want to ask you about the case as well. The department's letter to the court on March 15th said the department no longer defend the sentence. It also said the department had, quote, begun a process of reviewing the government's interpretation of Section 404 of the First Step Act after President Biden has sworn in. At the time, you were the acting assistant attorney general for the Office of Legal Counsel. Were you involved in this review of Section 404 of the First Step Act in particular, or the broader interpretations of the First Step Act?
No, I wasn't, Senator Cotton.
Well, if it wasn't OLC conducting this review, who was conducting it?
Well, I don't know. I was unaware of the review. It strikes me as the kind of...
So you were the acting assistant attorney general. The department was conducting a review of its interpretation of a major statute, and you were not aware of this review?
Senator, I was not.
It's pretty amazing. How could the department have gotten it so wrong in this case? This is not a highly charged political case. This is not like the Yale University discrimination case, where the department decided that it was okay for Yale University to discriminate as long as it was discriminating against Asians. this was a statutory interpretation case that was easily decided below and then decided unanimously at the Supreme Court. How is it possible the department got it so wrong?
I'm sorry, I just can't speculate, Senator.
Okay. Reminds me of the old line that, do you know why the Supreme Court decided this case 9-0? Because there aren't 11 justices to decide it 11-0. Mr. Schroeder, the administration has come out in favor of a House bill that would grant D.C. statehood. Setting aside the political arguments about whether Washington should or should not be a state, I want to ask you about a very specific constitutional issue on D.C. statehood, namely the 23rd Amendment. Have you been involved in the department's review of that House bill and whether it's constitutional under the 23rd Amendment?
Yes, sir.
And what is your conclusion about that bill's constitutionality?
We have not completed an analysis, but we did take a preliminary look at the bill and participated in the formulation of the administration position.
And you believe that bill would pass constitutional muster if Congress passed it and the President signed it into law?
Well, that's a matter we're still reviewing.
So this may be a pretty simple take, but I think sometimes the simple takes are the right one. The 23rd Amendment, of course, says that Washington, D.C. is entitled to the number of electors in the Electoral College to which it would be entitled, quote, if it were a state, end quote. It's hard for me to imagine how a law could make Washington, D.C. a state when the Constitution itself refers to D.C. if it were a state. My time's expired.
Thank you, Senator Cotton. Senator Klobuchar is recognized for 5 minutes.
Thank you very much, Chairman. It is wonderful to be here with all the nominees. I'll have some questions of our judicial, our nominees here at the beginning of the panel. I notice you haven't been asked as many questions, but I will do that in writing. And I wanted to start out by asking you, Mr. Schroeder, and good to see you again, just to reaffirm some of the questions Senator Grassley had asked about the opinions from the OLC. Back in 2017, I sent a letter along with 5 of my colleagues to then AG nominee Sessions asking for his commitment to publicly disclose OLC's written legal opinions to the President. Do you think we should have a process for the department to review prior undisclosed OLC opinions to determine whether public disclosure is now appropriate? And do you think that's important for maintaining transparency?
Senator, thank you for that. Yes, I do think it is important for transparency. We do have a process in the Office of Legal Counsel to do a publication review of opinions that have not yet been published. I have not ascertained the status of the unpublished opinions that you're referring to. I would be happy, however, to communicate with you further about specifics. But in general, I do think that it is very important for the office to be transparent in the legal advice that it reduces to final opinions.
Okay. We talked about this, but during the previous administration, the Brookings Institute published a report on the reversal rate of the Trump administration's agency actions. Now you can go back and look at the whole time period, and they had a 29.5% success rate when defending agency actions, with previous administrations, including Republican administrations, having an average 69% success rate. Why do you think the reversal rate's high? And most importantly, you will lead an office that advises the executive branch on whether its actions are legal. How would you reverse the trend, and do you intend to do that?
Senator, I suspect we have to give better legal advice to reverse that trend to the extent we're participating. I haven't looked at the individual cases. I know the general failure rates that you're referring to. It's very important, I think, for the entire administration. I know the department feels this way, that we do our very best work interpreting statutes and staying within the confines of the statutes that Congress has enacted so that we can avoid the kinds of really unproductive administrative action that doesn't affect the purposes for which it's designed because they're reversed by courts. That doesn't sound like a very productive way to proceed to me.
Okay, very good. Ms. Greenfield, welcome back. Good to see you.
Senator.
Before rejoining the Justice Department at the beginning of this year, you served as a senior counsel on this committee, chief counsel to our friend Senator Hirono, and chief nominations counsel to then Chairman Leahy on the Judiciary Committee. And earlier in your career, you were a law clerk for a federal judge. Could you talk about how, with your background, how your views are on Congress's constitutional role to provide oversight of the executive branch, and what do you think is the role of the executive branch in responding to our inquiries and oversight?
Thank you, Senator. My time spent working as a Senate staffer and also in the Department of Justice has given me a keen appreciation and immense respect for the role of Congress. The role of Congress in conducting oversight, the role of Congress in legislating, and the Office of Legislative Affairs at the Department of Justice has a duty to assist Congress in those responsibilities as best we can, consistent with our responsibilities to protect confidentiality interests, to make sure that we protect criminal investigations and information protected by law, for instance, grand jury material. But it is important for the department to assist Congress. We should do the very best we can. We should always be listening very closely to what members of Congress are saying. They're reflecting important needs of their constituents and important aims, and we should try our very best to assist you when we can.
Very good. I appreciate that. And again, good luck, Judge Kelly, Ms. O'Hearn, and look forward to getting your answers on the record. Very pleased about your nominations. Thank you.
Thank you, Senator Klobuchar. Senator Kennedy is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm going to talk to our judicial nominees, and I'm going to stipulate up front to save you time and me time that you're going to follow precedent. Okay? Counsel, tell me the test that the United States Supreme Court uses to overturn its precedent. Counselor O'Hearn.
Thank you, Senator Kennedy, for that question. As you know, my practice has primarily focused on civil matters for the past 28 or 30 years. I have not had occasion to deal with a case where it would go to the Supreme Court where the issue of overturning its own precedent would be an issue, but they are obviously far and few between.
Okay. You don't know the test?
Sitting here today, Senator, I could not articulate that for you.
Okay, that's cool. Let's talk about a pretty famous case that we all learned in the first year in law school. Tell me the importance of McCullough v. Maryland.
Senator, I went to law school 30 years ago. I've practiced law for 30 years in many different areas for both plaintiffs and defendants in state and federal court, and I've not come across that case that I can recall and tell you it's holding as I sit here today.
Okay. Well, if you're going to be on the federal district court bench, you're going to come across the issue of universal or nationwide injunctions. What's the legal basis for a universal injunction?
Senator, I'm aware of the current discussion in the public domain about the propriety of district courts issuing nationwide injunctions. I've not encountered a case in my practice in state or federal court where that's been an issue. I think as a nominee, it would be inappropriate for me to comment on the propriety of that issue since it's currently being litigated.
I'm not asking about the propriety. I'm just asking you, do you know the legal basis for it?
Well, Senator, I know that federal courts are courts of limited jurisdiction and are supposed to be restrained in taking action and decide only the issues before them, involving the parties before them and the issues. Yep. And I think it would have to be a rare exception that an issue before a district court judge.
I know, but we both know universal injunctions are issued, and if you issue a universal injunction and you're asked by one of the litigants, well, why did you do that, Judge? What's your legal basis? What are you going to say?
Well, Senator, as I said, federal courts are courts of limited jurisdiction, and I think it would be extremely rare that as a district court judge.
But what's the legal basis, Counselor?
Well,
I'm just asking you what the legal basis is for a universal injunction.
Well, Senator, I think as a district court judge, if confirmed as a district court judge, I would need to have jurisdiction and believe I had appropriate jurisdiction to
Okay,
issue
let's move
that.
on. You're not going to answer it. Tell me the holding in Marbury versus Madison.
Marbury versus Madison is one of the pinnacle decisions about the judicial branch that, as you mentioned earlier, every law student learns in law school.
Yeah, what's the holding?
In terms of affirming that the judiciary is the interpreter of the Constitution.
Okay. What rule does the Supreme Court follow in determining whether an admissions policy of the university that uses race as part of the admissions process is constitutional?
Senator, my understanding is that race would qualify the application of strict scrutiny. And in cases the Supreme Court has addressed this issue, they have found that while quotas are not constitutional, that race may be a factor that's considered if there's a legitimate or rational purpose for it.
Okay. Let me just ask you personal philosophy on a couple of things. Do you believe that that crime is a disease that we should try to cure, or do you believe that it is antisocial behavior that should be punished?
Senator, my practice over the past 28 years has been in the civil arena. I have
Right.
not had occasion to practice criminally.
I'm just asking your philosophy. I'm not asking the law.
Absolutely. But I will say that from what I have seen and as a human being, as you referenced earlier, I think that that's a very complicated question.
Yeah, that's why I ask it.
I think there are many factors that would play into any case of any particular crime or defendant.
Can you tell me what you believe?
Senator, I don't know that I can say one way or the other what I believe is
Have
to
you
answer
thought
the
about
question. I'm sorry?
Have you thought about it?
I can't say that it's something that I've given an extensive amount of thought.
Whoa. Okay.
I think it's very complicated.
Thanks, Mr. Chair.
Thank you, Senator Kennedy. Senator Whitehouse is recognized for 5 minutes.
Thank you. And just for the record, I've been the state's attorney general with plenary criminal authority, and I've been the United States attorney, and I haven't given much thought to the question of whether crime is an illness or behavior. You're presented with a set of facts. You have laws. You apply them, and you try to make sure you deter crime, and where people need treatment, you try to make sure that they get it. I think that's a pretty simple answer there. If I may, let me start with Ms. Greenfeld. I'll focus on the DOJ witnesses. You are probably well aware that I have been a constant critic of the persistent and recurring refusals by the Department of Justice and the FBI to answer committee questions, a persistent and recurring refusal which seems to rise in difficulty in sync with the likely difficulty of the answers were they to be provided. You aren't terrible about getting the easy stuff to us, but anything that looks like it might be required to disclose something challenging, it pretty much stops. Now, there are variations around that. The FBI wouldn't tell me what their tip line rules are. Refused to answer that question. We were able to find out through internet searches that the FBI publicly disclosed what its tip line rules were in other forums, and so we were able to find it that way. So from the FBI's point of view, even public stuff like that were being denied, probably because it touched on a difficult topic, which is whether the Kavanaugh tip line was real or not. But I don't think that's acceptable. And at the other end, when stuff actually could have a real law enforcement concern about it, we've seen a fast lane that runs around the Stonewall, the traffic jam, and brings stuff, including pretty delicate FBI stuff, directly to at least the Republicans on the committee when they wanted to investigate the FBI investigation of the Trump committee. So there doesn't seem to be a solid rule here. We've heard every excuse in the world. It has to go through OMB. Well, great. The political operatives at OMB stopping information that is duly requested from the Department of Justice, I don't think is a good outcome. There's an interagency process. Well, I mean, you can invent an interagency process to slow things down. That doesn't seem very credible to me. There's a new Congress, and so stuff we've stalled you on for 2 years, we're going to now ignore. That is, I think, an imagined obstacle. And very often just no excuse at all, just total stonewall. So can you give me any assurance that this nonsense will stop? And can you give me any assurance that you will have some authority over the FBI, which has been its own separate set of disclosure problems?
Senator, I am aware that you have sometimes been a critic of the responsiveness of the department. I appreciate your need and the need of every member of Congress for information from the department for purposes of oversight on legislation. I can assure you that we, and the Attorney General has instructed us to respond to every inquiry. And when there are times that we feel that the balancing test that we use doesn't permit us to reveal some information or produce some documents, that we explain why.
Yeah.
And that we be clear.
That's the way it's supposed to work. That's the way it works in civil discovery. That's the way it works in criminal discovery. That's the way it works everywhere. And we just have varied from that now for quite a long period of time at the Department of Justice. So good. I will count on you to fix that. Mr. Schroeder, you're coming into the OLC, which has its own rather unfortunate history. There are a variety of highly critical decisions of OLC memoranda and opinions, the most recent one being Judge Amy Berman Jackson's slamming of the OLC conduct in Crew versus DOJ. Before that, you had the twin poundings in Committee on the Judiciary v. McGahn of Judge Ketanji Brown Jackson and of Judge Marrero up in the Southern District of New York in Trump versus Vance. And interestingly, the latter two referred back to the Committee on the Judiciary versus Myers, which slammed the OLC decision on absolute immunity, which OLC didn't seem to take seriously as a judicial decision because it was still making the same arguments 10 years later in Vance and McGahn cases. So, every time an OLC opinion seems to get in front of a court, it gets pounded into the ground, and that doesn't seem to be a good thing. I think ignoring Myers, and I don't know if OLC is going to respond to the other decisions I just mentioned, or if they're just going to bull their heads down and say, we know better, and insist on sticking by their guns, even when judges have overruled them. You've got the whole question of prosecuting the President of the United States, which OLC has put into a box canyon so that it never gets judicial review, which I think is an absolute just a seizure of authority that it doesn't belong. And then you've got this history of department revolt, both on the torture memos out of OLC. When they became public, the department in that administration blew up and withdrew and corrected them. With the warrantless wiretapping cases, people threatened to resign if the conduct continued that the OLC had approved. So you've got a real problem on your hands, and I think OLC has a real credibility problem with courts and with this committee, and we can spend more time talking about this, but I wanted to put that on the record and give you the chance to make a quick response of how seriously you take this record of problems at OLC. It used to be the great place, the high temple of the law in the Department of Justice. Bring it back and respond.
Thank you, Senator, for the encouragement and the litany of the what I hope will be viewed from the perspective of history, aberrations in the work of the Office of Legal Counsel. I know all the instances to which you have referred. It's my intention, if I'm fortunate enough to be confirmed, to aspire to the highest quality analysis that we can achieve, and that certainly will take cognizance of judicial decisions that differ from interpretive stances that the office has taken in the past, and much more. So we are hoping that we will be able to have a conversation with you 4 or 5 years from now in which the litany will feel a little more dated than it does now.
Good. Well, count on me to be a persistent scourge, thorn in the side, nag, pain in the rear, whatever you want to call it, until we get that back, because it's a really important part of the Department of Justice. And when it sends signals like that, it harms the reputation of the entire department. So thank you.
Thank you, Senator Whitehouse. Senator Cruz is recognized for 5 minutes.
Thank you, Mr. Chairman. Welcome to each of the nominees. Ms. Greenfield, let's start with you. You were chief counsel to Senator Hirono during the now infamous confirmation of Justice Brett Kavanaugh. As we know, after Justice Kavanaugh's first hearing, when it was clear that he had the votes to be confirmed, somebody on this committee leaked the allegations by Dr. Christine Blasey Ford to the publication The Intercept. Do you know who leaked Dr. Ford's allegations to The Intercept?
No, sir.
Did anyone on the committee ever tell you or otherwise communicate to you who leaked the story to The Intercept?
No, sir.
When did you first learn about the allegations against Justice Kavanaugh?
I think when they were in the news.
All right. Mr. Schroeder, you and I had a good conversation this week. The Office of Legal Counsel is an extraordinarily important office of the Department of Justice, one that in more recent years has had less respect than it had in prior decades. As you and I discussed, a major reason for that has been the willingness of OLC at times to subordinate following the law to the political or policy priorities of whichever administration happens to be in power. How should the Office of Legal Counsel handle an issue when there is a conflict between what the law provides and the political or policy priorities of the administration?
Well, Senator Cruz, I think the responsibilities of the Office of Legal Counsel, and certainly my intention, should I be confirmed to be able to lead it, is a very direct injunction to interpret the law. We are not a policy-making operation inside the Department of Justice or inside the administration. Our function is to, through delegation from the Attorney General, to fulfill that obligation to provide the best legal advice in an impartial and independent way to the executive branch.
Now, when you and I talked in the office, you also expressed concern about the decision early in the Obama Justice Department when the Office of Legal Counsel had given a particular opinion concerning the District of Columbia, the Attorney General's decision to go instead to the Solicitor General and seek a different opinion. And you expressed concerns in terms of the institution of the Department of Justice. What are those concerns you have?
Well, the instance you referred to was an occasion in which the Attorney General sought the advice of the Office of Legal Counsel and then sought other advice from the Solicitor General. I think as a general operating rule, that's not a good practice. I think the department should be relying upon the Office of Legal Counsel, which, by the way, consults in difficult matters on many occasions with the very skillful attorneys who are in the Solicitor General's office as well as the other components in the department. So hard issues that the Office of Legal Counsel faces are the object of discussion, debate, advice with skilled people throughout the department. So we perform something of a collecting function when we are trying to wrestle with a hard problem. And if we've gone through that process in that careful, thorough, deliberative way, it would be my hope and expectation that that's the advice that would be followed once we give it.
Okay, Judge Kelly, I want to ask you about a case, Commonwealth versus Moniz. In that case, you allowed a dangerous, violent, illegal alien to vacate his guilty plea. This defendant originally pled guilty to 2 counts of armed assault with intent to murder, 2 counts of assault with a dangerous weapon, 1 count of possessing a firearm without an FID card, 1 count of carrying a loaded firearm without a license, and 1 count of malicious damage to a motor car. During his plea colloquy, you warned him that, quote, if you are not a citizen of the United States, your guilty plea can result in your deportation, exclusion from the United States, and denial of citizenship. Sure enough, several months later, after his guilty plea, ICE determined that this violent, criminal, illegal alien was deportable. However, you decided to vacate his guilty plea because you said, quote, the interest of justice required you to do so because you, quote, inadequately warned the defendant of the immigration consequences of his guilty plea. Why wasn't your warning very clear, and why would you allow an admitted violent criminal to vacate his guilty plea?
Senator, that case, the defendant had filed a motion to vacate his conviction, or his guilty plea, excuse me, because I had failed to advise him that he could be denied admission into the United States per our statute. And so that was the reason why I denied it, and then it was reversed by the appeals court.
But wasn't your warning clear and sufficient?
It was not a verbatim warning but as required by the statute, so I thought that I had made an error, and so I tried to correct that error.
Thank you.
Thank you, Senator Cruz. Senator Blumenthal is recognized for 5 minutes.
Thank you, Chairman. Thank you all for your service. I'd like to begin with Ms. Greenfield. And I know that I am repeating in some part ground that's already been covered in raising the politicization of the Department of Justice's response to questions and requests that have been posed in the past. In the previous administration, your office or the office to which you have been nominated would respond quickly to oversight requests from Republicans, not so much from Democrats. In fact, members on this side of the aisle were routinely stonewalled by the Office of Legislative Affairs in the Department of Justice. And so I would like your commitment that you will, in fact, restore the integrity and independence of the Office of Legislative Affairs.
Yes, Senator.
I'm confident that you will, because you have seen it from our side, as well as I know from your previous experience, your commitment to the goals and mission of the Department of Justice. Over the last couple of years, I have been involved with families that suffered losses on 9/11. They have sued the government of Saudi Arabia. The Senate of the United States enabled them, in effect, to get relief in that lawsuit through the JASTA legislation. President Obama vetoed it. We overrode the veto. They are proceeding with their litigation. I'm not taking an advocacy position in the litigation, but I know that they have been denied information that is absolutely essential to their day in court. And the Department of Justice and the FBI has invoked the state's secret privilege to withhold documents, testimony, and information that is relevant and important to that litigation. I've sent letters on this issue in February and May of this year, which follow up on letters that I sent in 2019 and 2020. I have been joined by various colleagues in these letters. I've received no response. I've asked Attorney General Garland about them, most recently in the confirmation hearings, that is, the public discussion with him. And I asked Director Wray about this issue in oversight hearings. I would like a commitment from you that there will be a response from the Department of Justice to these inquiries that I've posed. And further, I would like to suggest that the Department of Justice should avoid standing in the way of these families having their day in court and should provide the public and them with an explanation as to why this information is continuing to be withheld. They owe that explanation to the American people as well as these families. Can you commit to me that you will be responsive to these requests?
Yes.
Thank you. On February 19th of this year, I wrote to then acting Attorney General Wilkinson concerning the Department of Justice's failure to release a long pending Inspector General report on the FBI's mishandling of the Larry Nassar investigation. You will recall, I'm sure, that Larry Nassar was convicted and sentenced to life imprisonment as a result of his abusing young girls, women, in the Olympics training program. I have yet to receive a response to this letter, and there's been no report issued on the IG investigation. Will you commit that you will be responsive to these requests that I have made for release of that report?
Yes, I will.
Thank you. Mr. Schroeder, I know from your previous and current tenure as Deputy Assistant Attorney General at the Office of Legal Counsel that you are committed to independent and principled advice on the application of the law to ensure the administration of justice. I hope that you will, if confirmed, fulfill that goal. I'd like to ask whether you will commit to reviewing the opinions of your predecessors for instances of improper political influence.
Senator, I don't come to the office. I would not come to the office if I'm fortunate enough to be confirmed with an agenda to go back reviewing prior opinions of the office. That's, to my knowledge, no predecessor of mine has done that. At the same time, to the extent that there are opinions that take positions that are relevant to questions that we are being asked by the current administration, and therefore we look to them for what they have said, and they will determine that they are mistaken, we will not hesitate to revise them and revisit them as the case may be, depending upon the contents and the merits of the individual opinions we're reviewing.
I think accountability is important, and I hope you will go back and review those prior opinions for mistakes, for errors in legal opinions. But if the reasons for those mistakes or errors were related to improper motives or benefits, accountability is important. I recognize this issue runs through the Department of Justice and the new administration's evaluation of past performance. But in a number of instances, as I have raised with the Attorney General, when he sat where you are in his confirmation hearing, I think that the Department of Justice, which is responsible for law enforcement, has a responsibility to review its own past performance for possible law breaking. And what I'm asking from you is a commitment that you will, in fact, report to us in the event you find impropriety or law breaking in your review of those past opinions.
Senator, I appreciate that, and I appreciate your wider concern about the department. As I'm thinking about this, it is very difficult to ascertain intent when you're reviewing a formal legal opinion. And it would require, it seems to me, a great deal of forensic inquiry into the circumstances around the creation of opinions about which we don't keep precise records. We keep precise records about what we write, not about interactions of the kind that might lead to an interest in exploring the possibility of improper influence. Should we come over that kind of circumstance, we will certainly draw it to the attention of the appropriate leadership components of the department, because I think that's the kind of referral that would be appropriate in the first instance, should we come across that kind of situation.
Well, I hope that you will be proactive in that review and that you will report any indication of impropriety or wrongdoing. I want to ask you about a specific Office of Legal Counsel opinion. On January 15th, 2021, at the tail end of the last administration, there was a memorandum of opinion issued for the Bureau of Prisons relating to home confinement for federal prisoners after COVID-19. The opinion essentially commands the Bureau of Prisons to stop home confinement under the CARES Act for medically vulnerable inmates and to haul them, in effect, back to prison from their homes, even though they were nonviolent, posed no harm, no danger of harm to the community. And that interpretation strikes me as unnecessary and cruel and possibly even vindictive. So I would like to get from you a commitment that you will review that opinion and correct it if, in fact, there's no legal basis for it and, in fact, it serves no public policy purpose.
Senator, this, I think, is a very important issue that you've raised. I'm aware of the situation. I know that the leadership of the department is actively engaged in working out the most humane approach to the inmates who have been released into home confinement early that you have referred to under the CARES Act. And I will commit that our office will provide whatever support the leadership office requires of us in order to develop a policy that is consistent with the laws as we understand them.
Senator's time has expired.
Yeah, let me just conclude by saying I don't know what that means. You know, I'm asking that you review an opinion that essentially, in my view, was simply vindictive, unnecessary. I know Senators Durbin and Grassley have expressed the same concerns about this memo. I'm asking for a commitment to reevaluate this opinion under the CARES Act and other controlling legal authorities related to home confinement and the pandemic. And I am disappointed by a failure to commit clearly to reevaluate that opinion with respect to inmates who are medically vulnerable and pose no risk to public health or public safety.
I appreciate that, Senator. What I can tell you is I will commit myself to working with the leadership officers who are now engaged actively with this issue to ascertain what is the most appropriate and humane way forward.
Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Whitehouse, recognized for 5 minutes.
I won't take 5 minutes. This will be very quick. One will be a question for the record to Mr. Schroeder, and that is that I would like to ask you to, when you get in there, get for me a description of what was done at OLC between the Magan decision in 2019 and the Vance decision in 2019 and today's date at OLC to reconsider the merits of the OLC opinions that were critiqued in those judicial decisions. Okay? And the purpose here is to test whether, before I ask this question, OLC undertook any steps to reconsider its own undercut opinions in the light of the judicial decisions, the Article 3 decisions that undercut them. So can you get me that information once you're in?
Understood. Yes, I will.
Great, thank you. And Ms. Greenfield, this is a process question. So many of the problems we've had with selective response to committee questions and highly politicized selective response to committee questions have come out of the FBI. And as a former U.S. attorney, I'm aware of there's a certain amount of healthy rivalry, if you'll say, between the FBI and the DOJ. I heard it once said that the problem with the Department of Justice is it doesn't understand that it works for the Federal Bureau of Investigation. And so there's always a bit of a tension there. Do you, in your position as OLA at DOJ, oversee and control how the FBI responds to us? Or does that go through a separate channel that you do not oversee?
There is some consultation when responding to requests, but the FBI does write, and the director signs, or the head of the Office of Congressional Affairs signs letters addressed to the FBI.
Over at the FBI?
Correct.
So we have to have the same conversation with the FBI Office of Legislative Affairs because you don't control the FBI's response to our requests. The FBI does that.
But we work with the FBI, and there should not be, as you described, any kind of preferential answering or refusing to answer on any basis that's partisan in any way, and that is the job of the office.
If this gets kicked up to the DAG's desk or the Attorney General's desk, at that point, the FBI has to conform to what the Attorney General and the DAG decide. That's correct?
Yes, and the Office of Legislative Affairs does have cooperation, and we work very closely with the FBI, and we can do better. We should do better in that relationship.
Great, and it may take the deputy or the Attorney General to make them do better, and that's in the chain of command. So I look forward to working with you in that structure, and I appreciate your clarifying all that. Thank you very much, Chairman.
Thank you, sir.
Thank you, Senator Whitehouse. Thank you again to our panel. Before adjourning today's hearing, I will enter a number of letters into the record, make a few logistical notes. We've received several letters of support for today's nominees, including letters of support for Judge Gelpi from the Federal Bar Association and Puerto Rico Bar Association, a letter of support for Judge Kelly from the Massachusetts Association of Hispanic Attorneys, letters of support for Ms. O'Hearn from, among other organizations, the New Jersey State Bar Association and the Ironworkers Local Union 399, and a letter of support for Mr. Schrader from more than 30 academics and former executive branch lawyers. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, June 30th, and the record will likewise remain open until that time to submit letters and similar materials. Thank you again to the nominees for your attendance and answers today, and with that, this hearing is adjourned.